like to mention item number 11, my lord.
11?
My lord, that matter may be possible for that day, my lord, that take on the next week, my lord.
Acha.
I have already taken consent from the petitioner.
You are the CGC?
CGC, my lord.
11?
Item 11, my lord.
Okay. Right. Mr.
B. Sharma.
B. Sharma,
CGC, my lord.
the learned CGC, prays for a short accommodation
My lord.
and requests the matter to be listed on
My lord, that 21st, my lord.
21st of this month,
My lord.
21st of May 2026, list accordingly.
Obliged.
May I please your lordship, my lord? I'd like to mention item number 18, my lord.
18?
18, 1-8.
Okay.
Matter will be taken up next week, my lord. We need to obtain some instruction in this thing.
Acha. You are for the petitioner?
Petitioner, my lord.
Yes, right. In item number 18, Mr.
SK Chakravarti.
S.K. Chakraborty, learned counsel appearing for the petitioner, prays for some time, pays for an adjournment. You have informed the other side.
I am from the state government.
These are all state respondents.
State.
Vikika prays for an adjournment, which is allowed. And the matter is fixed on when? On June, during June, 2nd of June. Okay, that's a Tuesday, we can take it.
May it please your lordship. Also, I beg to mention item number 9 and 10, my lord.
9 and 10.
10, yes, lordship.
These are not hearing, I think.
My hearing.
Oh,
my lord.
hearing.
Yes, my lord. My senior.
2014
Yes, my
matter.
lord. My senior has some difficulty today, my lord. So can it be adjourned from other day for other
Senior
day?
means Mr. P.D. Nair.
Nair, my lord. He has some
P.D.
personal-
Nair, there was an adjournment yesterday
He
also.
has some personal difficulty. Actually, my lord, his wife is there in Chennai, lordship. So
Oh.
he has to attend a consultation with the doctor, lordship, today. So can it be in the month of June, lordship?
Yes. Okay, no further adjournment, huh?
Only? Yes, lordship.
Okay, heard Mr.
H. Rahman, lordship.
H. Rahman, learned counsel for the petitioner, who makes a prayer that the conducting counsel has some personal difficulty and has prayed for time. Prayer is allowed. List this matter.
23rd of June, lordship. If not,
23rd of June.
yes, lordship. It's not inconvenient, lordship. Well, lord, he has to go to Chennai.
23rd of June. He will come back. He will not take
He have
such
to
a
go-
month's period.
My lord, he have to go and regularly have to visit, my lord. So, my lord.
He's not there. He had
Today
to.
he is here, but he have to go and consultation online, lord.
Acha, acha. But then 23rd will be too long. Let it be fixed on 9th of June. Will be too early. But 9th of June, see, it's almost a month from today. That's a Tuesday.
My lord, in my lord, 15th of June, if not.
Okay, not 15th, 16th, since it's a hearing matter.
Yes, yes, lord.
16th of June,
Yes, lord.
2026.
Oblige, lordship.
May it please your lordship,
9 and 10, right? Hmm.
With
Yes.
with the consent of the other side, I beg to mention item 26 of the daily list. There's certain difficulty from our side today. A short
Okay.
accommodation,
Okay.
28th of May, if possible.
28 of May.
28th of May,
Okay.
hearing
Heard, Mr.
G. Kaushik for
G-
Bothakur.
You have taken consent from the other?
I'm appearing for.
Mr. Bothakur?
Wait.
Okay. Mr. G. Kaushik, learned counsel for the respondent number?
For the petitioner.
For the petitioner,
Petitioner.
acha. For the petitioner, prays that the matter may be adjourned due to some personal difficulty of the conducting counsel. Prayer is allowed. List this matter on 28th of May.
Much obliged.
I'm appearing for respondent to late notice.
Acha, which is not objected to by the respondent. Counsel appearing for the respondent.
Sir, please, your lordship. Lordship, I beg to mention item number 17, lordship.
17.
Yes, lordship. Sir,
Okay.
the consent of the other side, lordship. The matter may adjourn for 2 weeks, lordship. My senior is not keeping well, lordship.
This is 2018 matter.
Yes, lordship. He is not keeping well, lordship.
Hmm?
He is not keeping well today, lordship.
This is not?
Keeping well, lordship.
I cannot get you. This is not what?
He is not keeping well, lordship.
Oh, he is not keeping well. Mr. Mrs. MD Chaudhary,
MD Chaudhary, your lord.
you said he?
Yes, lordship.
Okay. I have not seen her for long.
Yes, lordship. He is not.
Okay. You are Mr.
And Borwa, lordship.
Mr. N. Borwa, learned counsel for the petitioner, submits that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter when? 2018 matter.
2 weeks time, lordship. I mentioned.
List this matter on 4th of June, 2026. Yes.
Please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 21.
21.
Yes, my lord. Here the engaged the engaged counsel, she's on medical leave. So we're praying for 1 week's time.
Yes, Mr. Kolita, you are there for the
I'm
petition.
appealing for the petitioner.
You are for the respondent.
For the respondent.
Yesterday, they have informed me, well, some date may kindly be
Hmm.
in the month of the.
May only.
itself.
Yes. Mr.
V. Keso, my lord.
B.
V. Keso, my lord.
V.
Appearing on behalf of RM Das.
R. Ali.
V. Keso appearing on behalf of RM Das.
RM Das.
My lord.
Okay. B. Kishore, on behalf of Mr. RM Das, submits that the conducting council, what?
Yes, my lord.
The conducting council has some personal difficulty and has prayed for some time, which is not objected to by Mr. Kolita, learned counsel for the petitioner. As such, fixed this matter on 28th of May.
Much
Okay,
obliged.
on 28th of May, 2026.
Yeah, please, Your Lordship. Lordship, in item number 8, this morning we have filed a reply. Your Lordship may kindly allow it to bring it on record, Your Lordship.
Okay, give the requisition.
My lord, I beg to mention item number 15, my lord, 15.
1-5.
My lord.
Yes, 2018 matter again. These are all old matters.
My lord, can it be taken up on 26th or 28th of May, my lord? I'm appearing for respondent number 5, my
Respond number 5.
lord. Yes.
You are there for the, yes,
Petition.
Mr. Okay. Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for respondent number 5, submits that he has some difficulty in doing the matter today and has prayed for a short accommodation, which is not objected to by Mr. H. Sharma, learned counsel for the petitioner. As such, list this matter on 26th of May, this month,
My lord.
26th of May, 2026.
Much.
Item 23.
Yes.
Lordship, during the pendency of this writ petition, the authority have passed an order dated 7/5/2026.
Passed an order?
This is the Department of Higher Education. Lordship.
Okay. Hmm.
May I place this?
Okay. So you got your relief?
Yes.
Dekha, heard Mr. Yeah, Mr.
L. Sanctam, Lordship.
L.
L. Sanctam.
L. Sanctum, learned counsel for the petitioner, and Mr. S. Bhuya, learned standing counsel
Higher-
for Higher Education Department. Mr. Sanctum has placed an order dated 7/5/2026, by which, where is that operative part?
Fourth line, Lordship.
Fourth line of which paragraph?
The first paragraph, Lordship.
First
Service
paragraph.
of following tutor assistant professor of Manabendra Sharma School, Girls College.
First paragraph is what? In exercise of authority.
Yes, Lordship. In the fourth line, Lordship. The service of following tutor assistant professors. Lordship.
Manavendra Sharma, he is
Yes,
the
Lordship.
petitioner.
Yes, Lordship.
No,
No,
Department
that is the
of-
college of the petitioner, Lordship.
Okay.
That is where the-
Mahavendra,
that is the-
tutor, assistant professor of Manavendra Sharma Girls College, hereby agreed, hereby upgraded to the post of
Upgraded to the post
assistant
of assistant professor.
professor in the regular UGC scale of pay. Okay, okay. So, I don't find your name here.
Name is not reflected, Lordship.
Oh, yes, Dr. Dipanjali Devi.
Yes,
So she is upgraded to the post of assistant professor in the regular UGC scale. This is what was your prayer.
yes, Lordship. If Lordship come to prayer number 1.
It's okay. Mr. Sanctum has, Koisuna has placed an error dated so and so by which the petitioner, by which the petitioner, no, by which the services of the petitioner is upgraded to the post of assistant professor in the regular UGC scale of pay, which was prayed for in the instant petition. As such, Mr. Sanctum submits that the petitioner got the relief she sought for and that he has instructions to withdraw the instant matter. Prayer is allowed. The instant matter is closed as withdrawn. The copy of the order dated 7/5/2026 is kept as a part of the record.
Deeply.
It will be, huh? বাওঁ হাতখনৰ দিগদাৰী আছে, থবলৈ দিগদাৰ হয়। এইখিনিতে থৈ দিম আৰু, হা? Item 1 and 2. Yes, Mr. Kumar?
Sir, in IPO in item number 1,
Mm,
like, in this case, madam, there are some recent developments
mm,
in regard to the pay rules and all,
Mm.
2017. Because it's regarding the pay parity of the electrician and the boiler. In terms of the pay rules of 2017, we get more than the boiler attendant and all.
electrician and the boiler.
Boiler. So we'd like to bring those documents on record because that will have a bearing on the outcome of this case
Okay.
also. So a short accommodation I seek from your lordship. We'll file it within 10 days.
You'll
or
file an additional affidavit.
additional affidavit bringing on record. The other party also, I'm told that they are filing it by today.
Acha. The item number 2.
So I pray that your lordship may fix.
You have, what did you say? Acha, finalized. Okay, you'll file it today itself. Okay, heard Mr. You are there for Mr. Pathak, you are there for?
APDC.
APDCL, okay. Heard Mr. B.D. Kumar, learned senior counsel, assisted by B. Soren, learned counsel for the petitioner, and Mr. K.P. Pathak, learned standing counsel for APDCL. You are for?
I pay for the APGCL.
What?
Honest.
AGCL.
APGCL, Lordship. 3, 4, 5, and 7.
Acha. So, Mr.
HR.
HR
Das.
Das. Learned counsel for what department you said?
APGCL, Assam Power Generation.
APGCL. APDCL.
ACL.
Okay. For APDCL and Miss K. Fukon for
Yes, sir.
okay, AEGCL for respondent number 6 and Mr. D. Bora for respondent number 1. Mr. Kumar submits that he got the instruction that the what the pay scale of the electrician is increased.
It's less than the boiler. Only in case of APG.
Was fixed in parity.
It was not fixed in pattern. That's the grievance.
Acha, the electrician's salary is lesser. Your plea is that it should be brought in equal.
Minimum at least.
at
In
least.
all other departments, as per the pay rules, it is more.
Mm,
And in all other departments, in some of the departments of government of Assam, where these pay rules are, they are the equivalent.
mm,
But this is the only department where it is less.
less.
And the only ground for giving more pay to the boiler attendant is it is a hazardous work. But electrical job is also a hazard.
Hazardous.
So we'll bring it on record so that it is convenient for this honorable court.
Bring in on record what the
Additional documents, madam. Will
okay.
have appearing on the matter.
Okay, Mr. B. Or learned counsel submits that he would like to file an additional affidavit bringing on record certain documents. The prayer is allowed. List this matter on
2nd of June, subject to your lordship's convenience.
2nd of June is a hearing day, I think.
Then,
So 3rd of June,
when the 3rd of June,
3rd of June, Mr. Pathak,
My lord.
3rd of June, 2026.
we are declared.
And in the second item also you write, heard Miss
Yeah.
S. Dev, learned counsel appearing for Mr. Miss M. Das, learned counsel for the petitioner, submits that heard Mr. So-and-so and Mr. K.P. Pathak, Miss, yes, your name? Miss S. Dev, learned counsel submits that she also wants to file an affidavit bringing on record certain documents, and she further submits that the affidavit is almost ready and that she will file it within the course of the day and has prayed for some time. Prayer is allowed. List this matter along with the other writ petition on 3rd of June, 2026.
Pass over the matter for timing.
Acha. After some time. Is Sosma Bakostu decided? Sosma Bakostu decided. Sosma Bakostu. Oh, that's it, Tom. Yes. Yes, Mr. Nag.
Lordship, I apologize. Lordship, here we were required to file an affidavit. This matter, Lordship, they have challenged the notification of the finance department, Lordship. So a detailed affidavit was required. We had received some instructions. I had informed my senior, Lordship. I apologize. We need further 3 weeks time, Lordship, because we have,
3 weeks.
Lordship, we have to file a notification has been challenged.
You already have the instructions.
No, that was not enough to, Lordship,
Acha.
defend our case, Lordship. That is why we are seeking just 3 weeks. The department has asked for 3 weeks time, Lordship.
Okay, Mr.
My lord.
Nag? Okay, heard Mr. M. Nath, learned senior counsel assisted by Mr. F. A. Bhattacharjee, learned counsel for the petitioner, and Mr. A. Choliha, learned standing counsel finance department. Full stop. Mr. A. Choliha submits that he does not have the full instructions relating to this matter and that he needs some more time
Lordship.
to get the entire instructions and to incorporate the same in the affidavit. Prayer is allowed. List this matter on 10th of June.
Lordship.
That's a long time.
Lordship.
10th of June.
Fourth, my lord, can I make it fourth?
4th. Okay. 4th of June. That's a Thursday. Is this a hearing matter? No.
Not a hearing.
So 5th of June?
Or fifth or third also will do.
3rd of June will do?
Lordship. Lordship.
3rd of
Right.
June,
Obliged.
2026.
Right.
Yes, Mr. Bhuya?
My lord, several time had already been granted by
Sir,
this
it
honorable.
was sent
Not
for-
this time.
No, my lord, it was sent for vetting, my lord. May I pray this matter may take up on Friday, my lord.
Fine.
Already been sent
This Friday.
this Friday, my lord.
Last occasion also, you took time to file affidavit in
My-
opposition? Last occasion, February, time was already taken? Okay, on Friday,
Fine.
positively.
My lord, my lord.
Okay, heard Mr. A.R. Bhuya? Guচাই দিয়া। ইয়াত আছে। Heard Mr. A.R. Bhuya, learned counsel for the petitioner, and Ms. Chutia,
SPPM, my lord.
S. Chutia, learned counsel appearing for the elementary education.
Elementary division.
Elementary education. Ms. S. Chutia submits that she needs 2 days' time to file her affidavit in opposition. Prayer is allowed. List this matter on Friday, that is 15th of May,
My lord.
2026.
Record to agitation. My lord, in this case, my lord, record was called for, it has been received by today only, my lord. So I need some time to go through it, my lord.
Produce the records.
My lord.
So this tomorrow,
My lord. it can be,
Tomorrow?
my lord.
Well, tomorrow, can it be day after tomorrow, madam?
okay. Day after tomorrow is a hearing day,
Right.
so
Well, tomorrow, madam.
tomorrow,
My lord.
you have the records, it has
I
come.
have received, my lord.
Acha, you go through today.
My lord, my lord.
Heard Mr. M. Datta, learned counsel for the petitioner, and Ms. S. Chutia, learned counsel appearing for elementary education department. Ms. S. Chutia submits that the records pertaining to the instant case has been received today, and she requires some time to go through the same. Prayer is allowed. List this matter tomorrow, that is on 13th of May.
Obliged.
13th is an unlucky day. Hope your matter comes out good.
I hope so, my lord.
Item 7. Yes, Mr. Das? I think it came up on the last occasion and time was given. What is to be done today?
My lord, here the matter, we have filed one affidavit, my lord. The chief engineer has filed, my lord. But chief engineer now writes to the department has he has sent a copy to me that there was not sufficient material in the affidavit. So government needs to file. This is about regularization, my lord. So the government has to take a call, my lord. So already I have received a letter from the chief engineer writing to the government, my lord, to give me instructions. That is awaited. So, my lord,
What's the difference with chief engineer of
no,
what?
my lord. Chief engineer, my lord, he is the director. Whereas regularization part 3F, it has to be done by the government, my lord, by the commissioner secretary, special commissioner secretary, my lord. So, my lord, that instruction hasn't come, my lord. So,
So now the government will file an affidavit.
government has to file an affidavit, my lord. So I am praying for 2 weeks time, my lord.
Mr. Das, one after the other.
A government, who is the government, that's the main thing, my lord.
Yeah, that's what he said.
The chief engineer representing the government only.
No, my lord.
He's
No,
the
no.
appointing authority. Now, my lord, the question propped up before this honorable court, prior to your lordship taking on the matter, a legal issue was propped up. The court has asked us specifically, after superannuation, whether a writ of mandamus can be issued by the court or not.
Mm,
Because for regulation
Hmm.
of his service, because he was left out,
mm,
he was under 3F.
mm.
So a lot of employees continued, but somewhere he was left out. At one point of time, he was appointed in 94, then 94. Then thereafter, he continued not to disturb. Then what happened? Time to time, his service was extended in 3F. that at a point of time, his services was not extended. We came to the court by the civil rule. At that time, it was civil rule,
Mm,
98,
mm,
civil rule, not to disturb my service.
mm.
Now, subsequently, due to non-prosecution, the case was dismissed.
Oh.
But even then, he continued with the service. Long years.
Without
conti-
extension.
No, yes, he continued, government continued to accept it. That he continued for long, about 30 years of service he continued. Now, taking the help of Umademi,
Mm,
without the help of any interim order, if he continued more than
mm,
your lordship know the judgment,
mm,
so automatic service should be regularized.
mm,
Now, there was an OM which was issued by the government
mm,
in 2012, and they said that all master role worker who has put on more than 10 years of service, certain criteria, their service should be regularized.
mm,
Say, based on Umademi. So subsequently in 2015, they adopted the same and they issued an OM. Then who is department working under 3F, their services also should be regularized.
mm,
Somehow this particular petitioner, this service was left out.
mm,
Now this went to the law judicial department.
mm.
And judicial department, we have annexed that we made an RTI, and judicial department said this is absolutely is illegal, you can't do it. Somehow he was left out. Why all has been considered in all the department under 3F, so why his services should be not be regularized. So he's not getting a pension. So this should be considered. Now finance department also it went, there's a note. Finance department said yes, sir, that they want a particular opinion on, sir, two circular they have quoted, that OM.
Mm.
So now central government circular also they quoted, and all this has to be considered. Now today they filed an affidavit. The question that has been posed before the court was that whether a writ of mandamus can be issued even after superannuation, that is a judgment of the Supreme Court, detailed judgment of the Supreme Court, yes.
Mm.
All category, after the death also, how
Mm.
it has to be dealt, and after superannuation, whether services can be regular, that's the issue before this court.
So nobody should be deprived. That
Yes,
is what.
that's what, if your
Hmm.
lordship just, for a moment, I know your
But then
lordship
they want some
deferred,
time to
but
file their.
let them go through it, because their judgment is important.
Mm,
I think they can communicate to the department also,
Mhm.
because there may be a hunch behind, because the department
mm,
may think that no, after superannuation, whether regulation can be made or not. Please, my lord, 2025,
mm.
SCC online, SC 1735. This is Dharam Singh judgment and others. my lord.
1735.
1735.
So
Please-
mandamus can be issued even after
please see.
superannuation and all.
But 2 minutes, my lord.
Mm.
Your lordship can see it. They have categorized.
Mm,
And if your lordship looks into paragraph 19,
mm,
please see paragraph 19.
yes.
So see Roman 3,
Mm,
retired appellant,
mm,
and any appellant who has already retired shall be granted
mm,
regulation with effect from 24/4/2002 until the date of super pay fixation areas under clause 2 and recalculation of pension, gratuity and other terminal dues.
mm.
Revised pension terminal dues shall be paid within 3 months of the judgment.
Yeah.
Even this is appellant,
Mm,
all these, and they said compliance of the affidavit. So
mm.
this is what they have to, my lord, take an instruction. I think that's a narrow point, where narrow campus where the court have asked. And before this court has taken up, one of the court has said whether it can be granted or not.
Yes.
So this is a judgment which is 2025, my lord.
So Mr. Dhar, you have a talk with the department
My-
and let them know about this
My lord,
and file an affidavit.
my lord.
Your chief engineer's affidavit does not include this point of mandamus and all.
No, my lord.
Okay. You place it within 1 week or 2 weeks.
2 weeks. my lord.
Let them,
Cause, my lord,
let them
Wa-
take.
wa- wa-
But
wa-
see, the person has superannuated.
Yes.
He did not get pension.
pension.
When did he get superannuated?
In 31st March 2025.
25. So for 1 year, he has not got any penny.
No pension, nothing, man.
So make it fast, okay?
my lord.
Heard Mr. D. Das, learned counsel for the petitioner, or learned senior counsel assisted by Mr.
Yes, does.
S. Das, learned counsel for the petitioner, and Mr. R. Dhar, learned standing, no, government advocate,
PWD, my lord.
PWD, learned standing counsel for the PWD department. Mr. Dhar submits that although one affidavit has been filed by the chief engineer of the PWD department,
My lord.
of the PWD department, but it is, he has instructions to the effect that the said affidavit does not cover the entire gamut of the case, and that the government, and that the said chief engineer has written to the government of Assam that the government is required to file an affidavit in the instant case. And as such, he prays that some time may be allowed for the government to file an affidavit. Prayer is allowed. List this matter on. You have something to say, Mr. Das?
No, no, no. Which department, my lord? Which
He said
government?
PWD.
PWD. Government, he said government has to.
Government means, my lord, Commissioner Secretary, PWD, my lord. He is the government.
Government, that is Commissioner and Secretary of the PWD department. List this matter on 2 weeks means it will go after the holiday. So 29th of May?
My lord.
29th of May is okay?
29th of May, how?
That's a Friday. Or 1st of June?
1st of June, there is not difficult. Thereafter,
Or
after second, third,
third,
fourth,
third,
third,
3rd June?
3rd June.
My lord.
Yes, Mr. Dhar?
My lord.
By 3rd June, it is made clear that the respondent side would file their affidavit without fail.
Let them serve a copy before in advance.
My lord, that obviously.
That,
we'll-
of course, before filing, they have to.
Yes,
serve
yes.
it.
Deeply obvious.
Yes.
My-
I'll keep this judgment in the file with the
You
records.
can keep it in the file.
No, I have just received a reply, my lord.
Hmm.
10 minutes back. I have just
think
received a
we-
reply from my affidavit, my lord.
Yes,
Well,
8.
More than this, my lord, this is a pension matter. There was earlier a round of litigation. The court gave a specific direction, pay the area.
Mm.
Up to that day, they cleared the dues. After that, my lord, the same situation has emerged. That's why we
They
have
had paid the arrears.
areas up to the day when the contempt petition was closed.
Mm.
After that, my lord, the same story.
Same.
Has,
No, there is some irregularity, my lord.
Mm.
From GMC, I have filed my affidavit
Mm.
and the reply has come today, just 10 minutes back, my lord. But main two government department is that Department of Housing and the Finance.
Mm.
That instruction, finance, I don't know, but find it appearing. And the Department of Housing, that instruction has to come on. Lots will
No,
put it after
my
3
lord,
weeks, my
your
lord.
lordship
In the meantime, I will put on affidavit on the Housing Department, my lord. That is the parent department, whether funds has come from the Finance Department, that way. The moment the finance amounts comes, my lord, it will be released, my lord. Only thing is that it has become irregular. It has been released earlier, it has become irregular, but the funds has not come.
Why it has become irregular?
One of the finance department had to issue the fund had to be come from the housing department, Housing and Urban Affairs.
Finance department cannot be,
And-
is not the responsible.
They will have to get the money, my lord. Only thing,
We release the money on the basis of the demand that has been.
yes.
So that demand is not made.
Demand had that instruction I need, my lord, from the Department of Housing. And I'm applying for Department of Housing. My lord, today the hearing has taken place. Let it settle down, my lord. Lot will post after 3 weeks. In the meantime, I will get all the instruction, my lord.
My lord, these are pension. People, in spite of getting their full salary, is difficult to survive nowadays. And they are not paying pension to even this grade 4 employees, the sweepers and the safai karmacharis and all. This is a very sorry state of affairs. So, my lord, this housing or the finance, it's a different department. The GMC has to gear up its own resources to meet up. Initially, there was contribution from the government. Now, today we have brought up the report of the pay commission also, which says that you have to create a fund to clear all these outstanding dues of the this pensioners. That has not been done. Malad, your lordship will make it specific. Your lordship will fix this matter also on 3rd of June. On that day, they should come up with a timeline at that by what time they will clear this areas, my lord.
This is
I'll
what?
put-
You are appearing for GMC. And
Yes.
what is housing?
Housing also I'm appearing, my lord. Instruction has to come from the housing because that.
Your affidavit is there on record. You had
Yes,
filed.
I have filed. Because of lack of fund, we are not releasing it. Because the command will issue. Give
Now,
us
what
the
has housing got to do with
The
this?
parent department or GMC.
Parent
This
department.
will have to get finance from the finance
But
department. Unless the funds
direction
come.
has to be complied by the GMC.
Mm.
If they have fund,
Already-
lack of fund, they should request the finance department.
Okay, you file your affidavit by, housing will file. Housing will file.
Housing will, yes.
File or you have to need, you just need the instructions.
No, that will not, what if there are communication.
Housing is not made a party, it is said.
Yes, yes.
Housing is the party, the parent
Oh,
department.
it's a party.
It's a party.
Because it's a
Yes, that's
department,
one number
but
two.
housing and urban
No,
will not
yes.
play. Your lordship kindly see
Is the, is the
kindly
parent
see the
department.
affidavit, paragraph 6 of the affidavit filed by the GMC at page 123.
Mm.
They are just, earlier also, but not even after we had to file it contempt. They give an undertaking to the court, they don't comply.
Mm.
Every time this pensioners has to come to the court. Your lordship, please see paragraph number 6. That as regard to the statement made in paragraph 15 of the writ petition, answering the pollen begs to state and clarify that regular salary of the employees of the answering corporation is paid from O&M account of the corporation, whereas pension is paid from fund released by government of Assam. As such, the source of regular salary and pension are different. So where is the requisition placed by the department before the government of Assam? They are silent. Simply by a cryptic 2 lines, they say she want to shift the burden to the finance department. The finance department today, I have heard saying that where is the requisition for the funds from the GMC?
Then the instruction will come, my lord.
Oh,
I
you
can
have
hand
to
over one,
state it,
one communication, my lord. Lords will see. I'm not an
Take it up on third then, but
Your
then
Honor,
come up
take it
with a
here.
proper affidavit.
proper affidavit, my lord.
And this time no adjournment because pension, these people are not
They are-
getting,
they are
from
not
what date they have not, they are not getting their
They
pension.
are not only getting their pension has
They got it till the contempt petition was closed.
irregular because of lack of fund. Only that is there. And we have, lordship can kindly see that later, my lord. We have asked the Department of Housing Affairs to release the fund.
No, housing.
Housing will release the fund.
The finance department,
They
their
will
affidavit
communicate
says
from
it is
the
the finance
finance department.
department.
It will be routed from the finance department, my lord.
Look, I have Mr. B.D. Kumar, learned senior counsel, assisted by Ms. J. Kumar, learned counsel for the petitioner, and Mr. S. Bora, learned counsel for the GMC, A. Choliha, learned standing counsel for the finance, and D. Bora, learned government advocate. This is from GMC to
GMC
housing.
to the Department of House, Secretary Department of Housing. How the funds are in, the next page, the amount, annual expenditure and all these things have been given, my lord. And they will, Housing Department will route it from the Finance Department.
Okay.
My friend is
Mr.
appearing for the housing department. Where is the communication from the housing to the finance? That's what the finance department is saying.
I will come up
Mr.
with the affidavit.
And Mr. S. Bora, learned counsel for the, learned standing counsel for the GMC, submits that although he has filed the affidavit by the housing department is required for adjudication of the instant case. And as such, he prays for some time so that an affidavit could be filed. Prayer is allowed. List this matter on 3rd of June, by which date the affidavit should be on record. List accordingly.
Deeply approved.
Problem.
You can take this, Mr. Bora. Huh? It will, ouch. Yes, matter ready for hearing.
Yes.
There's a review petition.
There's a review which I filed.
Mm.
Just place the case, my lord, so
Huh.
that you'll
Item number
understand.
is what?
petitioner.
12 and 13. Okay.
Petitioner tomorrow.
There is a state's
Let me
review
first-
petition by state.
Why this review has been filed by the
Mm.
state? Why review has been filed by the state?
Mm.
My lord, your lordship, just background of this case.
But let him start. Review petitioner is his.
Because to understand why the review has been filed,
Mm.
your lordship has to see in what context the review has been filed.
Mm.
That's why I just want to place, before review is being presented by my learned friend,
Mm.
if your lordships kindly take up 5066 of 2016.
Yes.
If your lordship and my learned friend allows me, for a moment, my lord, 5 minutes, 10
He's
minutes.
giving a smile, but that means he's reluctantly allowing you.
I have to, my lord.
Issue is very simple. My
Yes.
lord friend will speak as he wants.
No, I will just place
Issue
it.
is very, very simple.
Well, I narrow campus, let me place it, my issue, my lord. Why
He's
I
a writ
came to this
petitioner, let
court,
him say. Huh.
and then review why review has been
You
filed.
are a writ petitioner?
I am the writ petitioner.
Huh.
Please take up 5066 of 2016.
Yes.
Now, I will take your lordship to page 18. Please see the 18.
Mm.
I think facts is important than the law, my lord.
Mm.
Please see 18.
Mm.
This was the advertisement which was issued in 1998.
Mm.
Lordship got it?
Yes.
And was the post of Mandal. Please see after 3 lines.
Mm.
For filling the post of Mandal lying in vacant in amalgamated of office of so and so.
Mm.
Correct, ma'am? Now,
Yes.
now if your lordship kindly see at page 19,
Mm,
this is the mandal where we are selected,
mm,
list of selected candidates.
mm.
Lordship, please mark 14, 14, please mark 14, he's the petition number 1,
Kalicharan.
Dimbeshwar Barua at page 19.
Wait,
of
14 is
elected
Kalicharan.
29, sorry, 29, 29, serial number 29,
Dimbeshwar Borua.
Dimbeshwar Barua.
Mm. He is
Correct?
the petitioner?
He is the petitioner number 1.
One.
Yes.
Okay.
Now,
14
31,
is
No,
is
no.
not there.
29, 29.
Huh, 20.
29 is the first, Dimbeshwar Bora is the petition number 1.
Mm,
Now, please, 31
mm,
is Akhtar Ali, petition number 2.
mm,
Now, 32 is Rup Mohan Nath,
mm,
petition number 3.
mm,
I have been told that this person is no more, he is expired.
mm,
Now, next is 33
mm,
is Namimuddin Ahmed, his
Mm.
petition number 4.
mm,
34 is Champaram Kalita, his petition number 5.
mm.
And 35 is Probin Barua, his petition number 6.
Yes.
I have been told he is expired.
He also expired.
Expired.
Huh.
So these are the petitioner,
Mm,
my lord, who were selected in pursuance to advertisement of 1998.
mm.
Right, my lord. Now, and this is select list of 1906.
Mandal means that circle officer, circle office
Yes,
employee.
yes.
Okay.
Please see at page 19,
Mm,
down below,
mm,
1906, 1999.
mm.
This is a select list.
Yes.
Now, please turn
Mm,
to page 20,
mm,
long back WPC
mm.
of 2004,
Yes.
whereby, my lord, the matter was moved before this honorable court
Mm,
on 17/12/2024.
mm,
Now, the learned senior counsel is no more. He was a great lawyer, my lord.
mm.
According to me, he was a great lawyer.
Yes, yes. According
On
to
so
all.
and so, this
Mm.
was proposed to dispose of writ petition the motion stage itself with a direction.
Mm,
Commissioner Secretary so and so take action on letter dated 7/9 to the sent by DC so and so. Copy was sent to Commission according law. Mr. Monta Larnese has submitted at present there is a ban of
mm,
appointment imposed by so and so as submitted government advocate. Petitioner cannot be appointed in terms of letter, but this appointment may be made after lifting of the ban,
mm.
if so advised.
Okay.
Now, at page 25,
Mm.
31.
Although they were selected, they could not be appointed
Yes.
because of the ban.
ban.
So
Now-
once the ban is over, they were directed.
Yes, correct. Now,
Mm.
page 26,
Mm,
there was a review file
mm,
on 31/1/2005.
mm,
Please
Mm.
see, my lord, 31/1/2005.
mm,
Why review was filed? Please turn to page 27.
mm,
In view of the statement made in paragraph above, earlier order passed by this court dated so and so modified to the extent instead of directing
mm,
Commissioner and Secretary Government of Assam so and so, the DC Darang being the appointing authority for appointment of Mandal, directed to appoint the applicant review petitioner in vacant post of Mandal lying in the amalgamated establishment of present Deputy Commissioner after giving approval from government as per order dated 7/9/2024, immediately after lifting ban.
mm,
Because Commissioner is not the appointing authority.
mm,
So they were modified, the Deputy Commissioner is the appointed, so that
Mm.
order should be passed.
mm,
Now at page 28,
mm,
this is an order of 21/12/2005,
mm,
where office order was passed, and they have passed an order whereby this petitioner were appointed. Office order
by the deputy commissioner.
by the Deputy Commissioner,
Okay.
DC.
So the lift ban was over and then they were appointed.
Right, my lord? Now, 32 is the original and 28 is a type copy.
Mm,
Now, these were appointed. Please see, my lord, the appointment, and if you see at 32,
mm.
1, 2, 3, 4, 5, 6.
Yes, all the petitioners.
All these petitioners were appointed.
There were so many in the select list. Why these 6 people were?
They were left out.
Huh.
They were left out because immediately there was a ban. Out of 32,
Mm.
20 were appointed.
Before the ban.
Yes,
was
I
in-
will show it. Before the ban, it was appointed. Selection process, your lordship knows, at that relevant time,
Mm,
the selection process, 99 is the select list, but somehow there was a ban, so this was left out.
Mm.
But the selection is one.
Mm.
Advertisement is one.
Mm.
Now, if your lordship will see at page, now thereafter we were appointed, Now the gazette notification was issued
Hmm.
at page 35. Very short, I will say.
Hmm.
This gazette notification says one who is appointed after 1/2/2005.
1, 2 to
2005,
5.
they will be governed by the new pension rules.
Acha, acha.
New
1
pension,
to 2005,
yes,
governed by new pension.
new
rules.
pension.
So their appointment is after this date?
Please note down,
Huh.
21/12/2005.
21/12,
21/12/2005.
2005, yes. Hmm.
Right, man?
Hmm.
So this is what the gazette notification in short says, my lord.
Hmm. Where is that gazette
Please
notification?
see at page 35.
35, yes.
35.
Hmm.
See the first, my lord, this with reference to so and so introduction of new pension rules.
Hmm.
With reference to, I am directed to state that the pension liability of the state government has been rising exponentially. Government of India has already introduced a contributory pension scheme for the employees. State government is also formulating a similar contributory pension scheme applicable to 10-year
Hmm.
employees who will be in service of the state government on or after 1st of February 2005.
Hmm.
It has therefore decided, henceforth the following shall be incorporated in all the advertisements, filling up vacant posts under the state government, appointment letters of selected candidates,
Hmm.
government servant joining the service of state government on or after
Hmm.
1st of February 2005 shall not be governed by the existing Assam Pension Rule 1969. Orders issued thereunder from time to time so far as pension other equivalent benefit concerned. They will be governed by new set of pension rules which are being formulated in line contributory pension scheme announced by Government of India so and so. Fresh recruit joining the service on or after self-funded undertaking with joining report is prescribed below.
Hmm.
So this is what it says.
Hmm.
So once we receive,
This memorandum is applicable to all, right?
yes.
Hmm.
Now,
Then-
once we receive this, my lord,
Hmm.
immediately we file a writ petition before this honorable court. Please see at page 41.
That your process had started
that-
before it has come into
That's
force.
the only point.
Hmm.
See how it has been dealt on 21/7/2024. Body.
Hmm.
Applicants are invited for the post of mandal.
Hmm.
Petitioner applied for the post. A total of 38% were selected.
Hmm.
Of them, 23 were given posting. Rest of them were not, despite there being vacancy.
Hmm.
DC appears to have written a letter to commission to appoint rest of the pensions person in the selection list. There was no orders from the commissioner. Therefore, the person who was left out from giving appointment order filed writ petition before this honorable court. This court by order dated 17 of December 2004 directed to appoint a petitioner. Appointment petitioner made not on 1/2/2005.
Hmm.
There was an error,
Hmm.
the typography, which was corrected by the court.
Hmm.
The state brought into effect new pension rule with effect from 1/2/2005,
Hmm.
whereas the petitioner were not entitled to the benefit of pension.
Hmm.
Now, it is, date will be 21/12, 21/12/2000,
2005.
21/12/2005,
Hmm.
which was corrected
Hmm.
at page 44, my lord.
Hmm.
Now, my lord, please turn to 42.
Hmm.
It is a case of the petition that 23% who were appointed, whose name also figured in the selection list, were given the benefit of pension. Petitioner was denied the benefit of pension because of delayed appointment. It is therefore said that the action of the state in denying the pension is discriminatory. The council of the pen relied upon the decision of Supreme Court, State of Bihar and others in so and so, wherein it was held norms or rules as existing on the date when the process of selection begins will control such selection, and any alteration to such norms would not affect the continuing process unless specifically the same are given retroactive effect. In this case, the pension rules came into effect on 1/2/2005. Selection process of the petitioner was completed on 19/6/1995. Merely because the issuance of appointment order were delayed, petitioner cannot be denied the benefit of pension according to petition is allowed. Now, for correction of that date, 1/2/43, please see, that was corrected
Hmm.
by this court.
Yes.
Instead of this 1/2, it should be 21/1.
21/12.
Similar said order, so and so, corrected as so and so. So this was correct.
99. Hmm.
Yes. Now, my lord will see
Hmm.
that we have written at page 45 to the deputy commissioner
Hmm.
in pursuance to order that has been passed by the court. So we should be included under the old pension rules. Right, my lord? There, my lord, then we find it. Now, my lord, I have to tell one thing before lordship.
Hmm.
A contempt was filed,
Hmm.
but contempt could not be initiated because it was lapsed more than 1 year.
Acha.
So we took a leave of the court because there was an order at page 49, PC 49.
Mm.
This became a new cause of action at that time.
Mm.
We took liberty that to file a writ petition in view of the order that was passed on 22nd of May 2015 at page 49.
Mm.
Now please see what is the contents
Mm.
where DC wrote to the commissioner
Mm.
on 22nd of May 2015. My lord, the first is regarding entitlement to get privilege under so and so.
Mm.
My lord, if your lordship kindly
Mm.
see the last two paragraphs,
Mm.
as the process of the appointment was started
Mm.
from 99, basing on the same select list, petitioner claimed to get pensionary benefit under the Assam Service Pension Rule 1969 instead of new pension scheme.
Mm.
The Honorable High Court also admitted not to deny the benefit of pension to the petitioner as the process of the appointment was delayed.
Mm.
In view of the above, I would request you to communicate the government instruction order, etc. in this regard as early as possible dispose of the petitioner as above. So DC writes to the commissioner. Basically, this is what the order has been passed.
Dispose of the representation means.
Yes.
Mm.
Yes. Now, at page 51,
Mm.
they wanted the view from pension department.
Mm.
See at page 51.
Mm.
I am direct to request to kindly submit a detailed comprehensive note of the case. duly-
51.
51.
Mm.
With
I- what
reference
is-
to that letter, minor
Hmm.
letter number so and so.
That this is letter.
And this is
Hmm.
that letter,
Hmm.
15, say 22nd of May 2015,
Okay.
that
Hmm.
letter. If your lordship kindly see 51, with
Submit a
reference
detail.
to so and so, I am direct to request to kindly submit a detailed comprehensive note of the case duly signed by competent authority. Secondly, specify points on which P and PG department views necessary. Right? Now, my lord, at page 52,
Mm.
detail and comprehensive note as sought for.
Mm.
And this is a detailed note at page 53.
Mm.
See,
By the deputy commissioner.
by the
Yes.
ADC, that's the name. my lord.
Mm.
It appears, now please see on 53.
Mm.
It appears that a merit list of 38 candidates were prepared and published by DC on 1999. Observing all necessary formality in force, they were selected for the purpose of appointment
Mm.
in the post of Mandal under the amalgamated establishment of DC Darang.
Mm.
Petitioner Mandal so and so, all the names selected and names appear serial number 29, 31, 32, which I reflected already.
Mm.
Therefore, DC Darang initiated process for appointment of the selected candidates, due approval from government, as prior approval for filling up any grade 3 and 4 posts is essential. According, appointment of selected candidate was started in a phased manner against available vacant posts. After giving appointment of 29 candidates out of 38 from the select list of 99, please mark this, my lord.
Mm.
The government imposed ban on the appointment.
Mm.
As such, there was no alternative for appointment of the petitioner. Being agreed, petitioner approached the Honorable High Court for justice in terms of the appointment. Honorable Court was pleased to direct the authority, appoint the petitioner by an order so and so. Finally, obtaining prior approval from the government dated 19/12/2005, DC then appointed the petitioner and post of Mandal by dated 21/12/2005. Accordingly, they joined. At the time of appointment of the petitioner as Mandal, the new pension scheme had come into force, was introduced by the government, replacing earlier pension rule 1969. In case of new appointment, only made with effect from 1/2005. So automatically, their services came under the purview of new pension rule. Petitioner felt they were deprived of enjoying the privilege of earlier pension rule. They claimed that the whole process of the appointment was started from the year 1999 based on the same select list as prepared in the same year. So they would be entitled to get privilege of pensionary benefits under the Assam Service Pension Rule 1960 in place of new pension scheme. That came into force with effect from 1/2005. To draw sympathy and direction, they again knocked at the door of the Honorable High Court. Then the Honorable Court passed an order dated 21/7/2014 in so and so with direction. Petitioners cannot be denied from the benefit of pension as because the issuance of the appointment order were delayed by the authority.
Mm.
Secondly, the petitioner was selected during the year 1999 and they were appointed on 21/12/2005 after introduction of the new pension scheme 2005. Hence, the view of so as necessary for awarding pension under the purview of the Assam pension rule 1969.
Mm.
Now.
Again, some views.
Then, my lord, we could not come immediately to the court. We were on the duty, NRC duty from 54.
Mm.
We have stated all this from page, my lord, from page 54. We were entrusted various duties up to page 76,
Mm.
77, 78, 79, my lord.
Mm.
All these, then thereafter we approached this court in 2016. Not much, 2016 we were before this.
No,
court.
their claim was not rejected, only those views.
Views. They have not rejected. We came back, we are sitting today, they have not decided anything about this, whereas in pursuance with court's order,
Mm.
and that order was there. Now, when we filed
Mm.
this writ petition, my lord, they said that we want to file a review against the order of 2014. 2014 writ petition, where the order was passed by the court, we are entitled, number one, to get the old pension,
Mm.
because the selection process was started long back, 99 select list, 95 was the advertisement.
Mm.
Thereafter, out of 32, 28 was selected. It is not fault of us.
Mm.
There was a ban. So that order was passed. So when we projected, they said, no, we are going to file a review. 2017, they have filed a review against the order of that learned single judge, my lord. They have for page 41 and 42. That's what they have filed.
Mm.
Please see
By
41.
Justice Sridhar Rao.
Yes.
What
they-
they want to file a review.
They filed a review. This review was filed. Now, my lord, they want review of this order.
Mm.
Now, your lordship know very narrow compass of the review is.
Mm.
2 minutes review, my lord.
Mm.
It's a regarding discovery
Mm.
or there is an error apparent in face of the record on this. Or some new discovery has been made. That's a point.
Which was
be
not there during that time.
So this is what they file a review before this court.
Mm.
If review is allowed, the situation will be different.
Mm.
If review is not allowed, then end of the matter, my lord, my writ petition, my lord, with great respect, may be allowed by this honorable court.
Mm.
Now, what I have looked into it is very important, my lord. Whether any division were order, any order of division bench regarding old pension rule and the new pension rules. Whether one employee,
Mm.
suppose the process has started earlier,
Yes.
and this it was, they could not do anything, government sat idle. Thereafter, the appointment was made. After new pension rule. Now the question to be posed before this court, whether that employee will be entitled to get pension under the old or under the new.
There are any judgments by the
I
division
will
bench.
show a judgment of this court, division bench.
Even I think Supreme Court judgment will be there.
Right, but please see the judgment of the division bench of this court.
Mm.
Now that will clinch the whole issue.
Mm.
Then the review petition, my learned friend will address before this court. Review, I'll just show the judgment of this court and I will
Mm.
take my seat, my.
Mm.
मेरा कहाँ गया? Where is it? मैंने court बोले थे. ये तो बोला सर. Please see
Mm.
paragraph 2 first. I'll just close this, my lord, of this judgment.
Mm.
I'll close my case with this judgment.
Mm.
Please see judgment of division bench. My lord, the facts is important. एक मिनट कॉपी दे दीजिए, पैसा एक कॉपी. Please see, my lord, paragraph 2 first.
Mm.
The facts is important of the judgment. The petitioners are working as the superintendent group B of Central Goods and Service Tax as posted Dibrugarh and Agartala respectively.
Mm.
By way of advertisement dated 31 of January 2003, issued by the Staff Selection Commission, a combined graduate level examination 2003 for selection of candidate for recruitment to the post of inspector so and so, along with other posts were advertised. So Lordship, please mark 2003
3.
and our is 2098.
5 is the advertisement.
Yes. yes,
99 is the.
Correct. So please see, mark. Now, please skip it.
Mm.
First, then go, then bottom,
Mm.
after paragraph 2, 1, 2, 3, 4, 5, 6. Thereafter,
Mm.
on completion of required procedural formality and police verification, petitioner 1 joined his service on 5/8/2005. Please mark
Mm.
this. After new pension rules. After 1/2/2005. Our is 21/12/2005. Dates is important, facts is important. That's why.
So here the advertisement date is considered to be the relevant.
Well,
Here though things are more better than this.
our case is more better. than
Better.
I will show it
Hmm.
thereafter. Join his service to the post of so-and-so,
Hmm.
where he is subsequently promoted to so-and-so, right?
Hmm.
Please keep this. This is not so important.
Hmm.
Please see para 23 now. Para 23.
Hmm.
Please see para 23.
Hmm.
In the facts of the present case,
Hmm.
as there is no dispute that when the advertisement issued in the year 2003
Hmm.
and the selection process has commenced, the old pension scheme was in force.
Hmm.
That's what our case.
Hmm.
The judgment of Delhi High Court and Uttarakhand High Court were rendered on facts which are similar to the facts in the present case. Petitioner have also agitated the grievance by the representation dated 30/8/2017 before the respond authority. In the detailed representation preferred before the authorities, petitioner referred to the above orders passed by Uttarakhand High Court of so-and-so, as well as order passed by Central Administrative Tribunal, Ernakulam bench, and the Central Administrative Tribunal, Jabalpur bench. The said repentant, however, came to be rejected by communication dated 11th of December 2017, pursuant to which the petitioner approached the Central Administrative Gauhati bench
Hmm.
against the order judgment of the CAT.
Hmm.
24 is important. As discussed above, respond authority has not explained the delay of about 19 months, which has occurred from May 2003 to December 2004 for completion of selection process, declaration of result. Please, we'll pause for a moment here.
Hmm.
Now, here what they have delayed for completion of selection or declaration of result.
Hmm.
My case, the selection process completed, 99 is a select list. Our case is a better case than
Yes,
this.
better.
Now, that apart, the appointment orders or the petitioner came to be finally issued on 12/7/2005.
Hmm.
My appointment letter was 21/12/2005. Such delay which has occurred during the selection process as well as delay in issuing the appointment orders, please mark, cannot be attributed to the petitioner in absence of any explanation forthcoming from the respondent authority. Please, I'll put a pause for a moment. There was a ban. That's what the explanation they have given.
Hmm.
Here, there was no explanation given. Here, there was no explanation given. But here, the situation was worse
Hmm.
because, my lord, here, the selection process they kept. But the selection process was over.
Hmm.
And in view of the judgment of Mitlis,
Hmm.
where the single bench has relied on the judgment. Now, please see thereafter. Delhi High Court has rendered several judgments allowing writ petition where persons similarly situated as the present petitioner were granted the benefit of old pension rule, two of which, namely Tanka Ram and so, have attained finality in view of the appeal preferred by Union of India, have been dismissed by the apex court.
Hmm.
Under the circumstances, this court is persuaded to accept the view expressed in judgment rendered by Delhi High Court and Uttarakhand Court.
Hmm.
Accordingly, it is held that cases of petitioner being similarly situated ought to have covered under the old pension scheme of 2003 for reason held as above. I mean, we are not persuaded to accept the view expressed by so and so, which are relied upon respondent seems are not applicable. Writ when allowed by issuing a mandamus to respond, treat the petitioner as member of the old pension scheme, which was in force till December 31st, 2003. That's my case, my lord. So mandamus was issued, giving a direction.
Which was in force till December 31st, 2003.
Yes, which was in force till December 31st, 2000. But they came with a notification.
Hmm.
At that particular was given a time gap.
Hmm.
They came in a notification and they said only those will covered prior to 1/2/2005, they will get the benefit of the old pension scheme.
Hmm.
But once you are appointed after 1/2/2005, then you are entitled to get benefit under the new pension scheme.
Hmm.
Now, our case, we were appointed on 21/12/2005.
Hmm.
Similarly situated was appointed before, but there was a ban.
Yes.
Selection process took before that. Select list of 1999. So I think, my lord, these judgments covers our case, my lord. Better facts of the case, my lord.
Hmm.
So in that view of the matter, my lord, there nothing remains in the review also.
So let me see
But
what,
I say, my
what
lord,
error has
the
crept
one
up.
error that has been committed. If my learned friend can show that these are 2 or 3 grounds where there is an error which has crept up, your lordship will definitely examine the matter. That's my lord. They did not go to the appeal.
They should have gone to the appeal. You cannot do in guise of appeal. There are, but let my learned friends start with this. review.
Any Supreme Court judgment on this point?
Which point, my lord?
This new pension rule and old pension?
Bihar judgment, no, that's a new pension, old pension. That exactly, my lord, I think, what Bihar or-
If the
That's-
process starts
I-
before the new pension comes into effect,
But-
then they will
Oh,
be
that's a
governed by.
Bihar Judgment, but let's kindly see that judgment.
It's okay, that was Bihar judgment, this is Guwahati
Yes,
judgment, so it's
Right,
okay.
Yes.
Okay,
my
yes,
submission.
Mr. Majumdar.
Bihar, Midlands is Supreme Court, my lord.
Acha, acha, acha.
That's a Supreme Court.
Okay, okay.
Please take this judgment. Please take the judgment, my lord. Which refers by the learned single judge.
Mm. Any paragraph, relevant
Yes, yes.
paragraph here?
18 onwards. 18 onwards.
Mm.
We have carefully considered submission made on behalf of the parties, impressed with the stand taken by the petitioner, state of Bihar, the Bihar Police Service ought not to have recovered name of the respondent for appointment after so and so, and request coming not to recommend any further names in view of decision taken by the state to have so and so, professionally so and so. Both the learned single division bench rightly held that the change in the norms of recruitment could be applied prospectively and could not affect those who have selected
Mm.
for being recommended for appointment after following norms as were in place at the time when the selection process commenced. Respondent had been selected, recommendation to be appointed as assistant instructor in accordance existing norms. Before he could be appointed or even considered, the norms of recruitment were altered to the prejudice of respondent. Question is whether those altered norms will apply to the respondent.
Mm.
Now they are altered by bringing those new
New
pension to
norms.
the old pension.
Mm, yes.
But my selection process was at that time when the old pension rules were there. 98. Now please see 20. Decision which has been cited, 20, on behalf of respondent have clearly explained the law, applicability of the rule which are amended, altered during the selection process. They all say in one voice that norms or rules are existing on that when the process of selection begins, which controls the selection. Any alteration such norms would not affect the continuing process unless specifically the same were given
Given
retrospective effect. Now there is no retrospective effect. There is only after 1 to 2005. But that's what the judgment. So there are
But I think if there are some amendment in the procedural aspects, then that will be applicable. Not these cases.
My lord, I'll close my argument subject to what my learned friend advance.
Deeply obliged.
Yes, I'll take up the review application, Mr. Majumdar.
Madam.
Mm.
Yes. Thank you.
My lord, issue is not as has been
Acha.
discussed in the judgment. Of course, it's not a huge judgment, small order passed by Honorable Justice Sridhar Rao. Well, Honorable Justice Sridhar Rao did not enter into the question whether
2 minutes, can I take?
Yes, yes, of course. Yes,
I'll take a lot of that order, my lord.
of course, that order was short.
Short.
Mm.
Issue was, my lord, the judgments on which reliance has been placed. So far as this judgment of our High Court is concerned is slightly different. I'll come to that. Availability of vacancy was not the issue. In this judgment also, if your lordship goes to this judgment, paragraph 5, your lordship will find they is clearly mentioned that vacancies were there
Mm.
and recruitment process was also over.
Mm.
That would be a completely different thing. Here in our case, I'll show, my lord, vacancies were not available. There are two reasons for which they were not appointed prior to that cutoff date, my lord. In order to be entitled to the,
No, vacancies were available
no, my lord, that is what the difficulty. I'll just.
for accommodating these 6
Yes, my
petitioners.
lord, that is why your lordship put a question that the select list was of so many persons, why less number of persons were appointed? Because vacancies were not available.
But somewhere I got the appointment was done in a phased manner,
No, my lord,
not in relation to vacancies.
I will show the documents.
But even if vacancies were not available,
My lord,
by taking into account a division bench judgment, there too only advertisement was issued. And the old pension rule was made applicable.
no, my lord, in this case, vacancies were available. vacancies were available. In our case, my lord,
Doesn't matter, but appointments were not made.
yes.
And then also it is said that the old pension will be
It is-
applicable.
It is because, my lord, if the vacancies are available
Huh.
and there was a delay on the part of the authority in making the appointment,
Hmm.
then they will be entitled to their appointment from the date their entitled or the select list was there. But here is the case, my lord, vacancies were not there. That is why subsequently they were appointed when the vacancies became available.
But the main reason given is the ban on the appointment.
My lord, no, my lord, I'll just.
Oh, church. Show me.
Lordship, I have given small list of the other cases.
Yes, I've got it.
Two things are there, my lord.
So according to you, vacancy is not available.
Number one, and number two, while they got the appointment
Hmm.
and this 25/1/2005 notification
Came
Which-
into effect.
came into effect, and this notification itself says that now whenever any appointment is made, an undertaking will be taken from then.
That is also there. I've
That
seen somewhere.
undertaking, and they have
Hmm.
given the undertaking also.
Hmm.
So my first submission will be, because if this way they are given retrospective effect so far as their appointment is concerned, so as to make them entitled to the new defined pension scheme, there will be hundreds of thousands people will come and say that kindly give me also. It will be huge burden on the state.
No, that memorandum is not retrospective in effect.
No.
Only you are saying that there is a statement there that henceforth all appointment, there has to be an undertaking
Yes.
in respect of all
And
appointments.
they have pursuant to that, they have given undertaking also.
The petitioners have also given
Yes,
undertaking.
Yes.
That
No,
will not matter if
that
they
will
have
not-
the legal
Anyway,
right.
my lord, but then Lord will kindly see what is the difficulty
Hmm.
for which they were not appointed earlier, my lord.
Yes. Apart from ban, though, I don't see anything, but you
Yes,
can show
yes,
me.
ma'am. And Lord will kindly see page 23 of WPC 5072. My lord, that writ petition has been disposed of, but then that petition is tagged with this, my lord. Lord will just
5066.
5072
5072 is another writ petition.
Yes.
not yours.
by them only earlier, my lord.
5072, yes.
Lord will straightway turn to page 23,
23.
my lord.
Okay. Very old file.
It was the
Yes.
second round of litigation by them.
Hmm.
My lord, this is the document which will clinch the issue, my lord. This is a letter written by the Deputy Commissioner to the Commissioner and Secretary, Revenue Department, Government Master, my lord. In inviting reference to the above, I have the honor to state that a panel of 38 numbers of candidates.
This
who-
is not the same letter which is placed by Mr. Das. The Deputy Commissioner writing to the Commissioner and Secretary. This is a different letter.
My lord, I think, page 23, 9th March 2005.
2005. 9th March 2000. I had seen one letter written by DC. It's okay, it's okay. You
Well, yes,
proceed.
let
We
us
will see it
proceed.
later.
Yes.
Out of the data panel of 38
And
number of
38 numbers of
candidates.
candidates who passed the RCC training was prepared in the year 1999 for appointment in the post of Mandal, copy and close. Out of the 38 selected candidates, 30, not very clear, 33 or 30.
20 something like
Yes.
30 numbers.
Yes, had already been appointed as Mandal. Other selected 8 candidates could not be appointed by that time due to non-availability of adequate number of vacancies and also expiry of the select list. Subsequently, 6 numbers of selected candidates out of remaining 8 numbers had filed WPC number so-and-so and review application number so-and-so. It's talking about them, my lord. And the Honorable Gauhati High Court for their appointment in the vacant post of Mandal as they were duly selected. Honorable High Court in the review order did so-and-so passed in review application number so-and-so had directed the Deputy Commissioner Darang to appoint the applicant's review petitioner in the vacant post of Mandal in the amalgamated establishment of DC Darang getting approval from the government. It may be mentioned here that presently there are 61 number of post of Mandal lying vacant in the amalgamated establishment of the DC Darang Mangaldai. The matter of appointment of Mandal against the vacant posts were brought to the kind notice of the government from time to time by letter number so and so.
How can there be two different reasons for their non-appointment. Here, what I have seen in the other writ petition, it's only because of ban.
My lord,
Here they are saying that, is it in
ban-
respect of some other?
no, same, them only. My lord, ban was also there. Vacancies also were not available. Both were there. This is the problem, my lord. Both grounds were there. This letter is very clear.
But in the letters that he had shown, this aspect was not there. That they were, and even the select list expired.
Yes, select list expired, but subsequently it was extended, I think.
It was extended.
Yes. Now
Where
that
is it? This is on 9th March
March,
2005.
Soon after that notification of 1st of February 2005, my lord.
Acha, show me, Mr. Das, the letter that Mr. Das, D. Das had shown.
Page 49, my lord. At
Page 49.
I know.
of
I'll just see the difference.
page 49 of 5066 of 60.
Huh? Page 49. This is 22nd of May 2015.
My lord.
And this is much before that, 10 years before,
Yes, my lord.
Yes.
before their appointment. Before their appointment. They were appointed when? 21/12,
Yes, my lord.
2005.
Yes,
And this letter was before their appointment.
9th March 2005.
Hmm.
Page.
This 23? Yes,
21/12/2005, and this is before.
Yes, my lord.
No, Mr. Majumdar, this is in respect, this is before the appointment of the petitioners.
Yes.
Yes, my lord. That is what I'm showing, my lord. Lords, will you kindly see 1st of February 2005 is the new defined contribution pension scheme came into force.
Huh.
And that notification is there. Now, soon thereafter, 9th of March 2005 itself, that means next month,
Hmm.
this letter was issued. Till then, they were not appointed.
Huh, till then they were
They
not
were not
appointed.
appointed. And they were appointed on 21st of December 2005. Now, if your lordship goes to the judgment passed by Honorable Justice Sridhar Rao, lordship will find Honorable Justice Sridhar Rao has relied on a proposition and relying on that 83(3) SSC Maila Rangaia's case, which has been now overruled.
Hmm.
There it was said that rules, recruitment rules available at the time the vacancy arose will have to be applied for filling up those vacancies.
Hmm.
First of all, that proposition of law has been, my lord, overruled in, that judgment has been overruled in 2023. I've got that judgment, I'll show, my lord.
So the amended rules will be applicable.
Now Supreme Court says no, amended rules will be applicable.
And this is what
Earlier rules prevailing at the time the vacancy arose will not be applied.
I think what I
that-
know is if it is procedural part,
My lord.
then it will be applicable to the new appointments.
Yes, my lord. Other than this, my lord,
Hmm.
this proposition that the rules applicable at the time the vacancy arises will be applied to for filling up these posts is in respect of appointment. We are not concerned with appointment in this case, my lord. How Honorable Justice, this Honorable Court relied on the judgment to arrive at a finding that now they will be entitled to pension. Pension is a different thing. That proposition of law is in respect of recruitment, my lord. Not in respect of whether they will be entitled to the pension scheme available earlier because they were, because if that is the case, my lord, subsequently for all time to come, if somebody has been appointed, if someone can show that no vacancy was there, he will also have to be given. Now hundreds of thousands of people.
Okay, recruitment rules and pension are two different things.
My lord.
That will not be
My
applicable
lord,
here.
my-
But let me be clear with the facts.
My lord.
So the 38
Your
candidates
facts I
was
have given
prepared.
from my list of dates, Lord, will kindly see, I have chronologically given all the dates.
Yes. Wait, one second.
Advertisement, my lord, Lord, will kindly see first page, advertisement was of 1998.
Hmm.
Then select list.
95. Oh, in the judgment.
In the list of dates I have given.
Acha.
Then 1999, the select list was published.
Acha, let me take the list of dates.
My lord, just now I've given.
Yes, yes. Yes.
And 38 vacancies were selected, candidates were selected. Then out of 23 out of 30,
Without indicating number of vacancies, but I had seen in the advertisement.
there was no indication, my lord.
Wait, let me just check up.
Advertisement is silent.
Acha, this is age. Under this candidate.
Advertisement doesn't say the number of vacancies.
For a moment, my lord may take page 26 of 5066.
Acha, let him finish.
Lordship will kindly turn to
Okay,
page,
no vacancies, no, it is not shown.
not shown, my lord.
Huh.
And that is why in this list of dates, Lordship will find
Hmm.
38 candidates were selected,
Hmm.
23 were initially appointed.
Hmm.
Then 12th September 2000, Deputy Secretary issued instruction to Deputy Commissioner Darang to extend validity of select list up to 31st of December 2000
Hmm.
as more vacancies were available.
Those were anticipated.
Nothing, my lord. My lord, the difficulty arises, Deputy Commissioner at the instance of the, my lord, candidates keeps on writing letters without having any reference to the actual fact. This creates the all confusion, my lord.
Hmm.
Then 17/12/2004, WPC 9299, this is the first writ petition filed by them,
Hmm.
disposed of directing Commissioner to take action on their letter of 7/9/2004 sent by Deputy Commissioner Darang to Director Land Records. 25th of January 2005, Government in Finance Department informed all concerned, including all the Deputy Commissioners, that due to exponential rise in pension liability, it is decided that a new pension rules on the lines of contributory pension scheme of Government of India was being formulated, and all fresh recruits joining service on or after 1/2/2005 shall furnish an undertaking that they shall not be governed by the Assam Services Pension Rules 1969.
Hmm.
Then 31st January 2005, in review application number so the above order was modified to the extent that in place of commissioner, it is DC. So it has got nothing to do with the merit matter. Then 1st February 2005, the new pension scheme comes. Then 9/3/2005, this letter which I have just now read, my lord, says that earlier there was no vacancies were not available. Now, please, by this letter, it was requested, kindly communicate approval. Then 9 December 2005, Deputy Secretary, Revenue Department accorded approval.
Wait, what is Deputy Secretary, Revenue Department?
My lord.
Comes Secretary to communicate approval of filling up of 6, okay.
Yes.
Huh. Then
Then next is, my lord,
9/12.
Deputy Secretary 9/12, Deputy Secretary Revenue Department accorded approval for filling up 6 vacant posts of Mandal. Then writ petitioners were appointed as Mandal on 21/12/2005. Lord will kindly see after the cutoff date. Then 22nd August 2006, Deputy Commissioner asked petitioners to furnish undertaking as per provisions of new defined pension scheme, which provides that government servants joining on or after 22 shall not be governed by existing pension rules of 1969, but by new pensions rules formulated on the lines of contributory pension scheme of Government of India. Agreed by the above requirements by Deputy Commissioner, petitioner filed WPC 5072 to direct the respondents to treat them equally with 32 persons appointed from the same list, select list, giving all benefits, including pensionary benefits.
So they did not give an undertaking, they came to the court. They were asked.
They have
give it.
given the undertaking and then they came to.
But then you did not write it here.
Yes, ma'am. Then WPC 5070 was allowed holding that, I'll go to that order, my lord. Selection process was completed on 1995. Merely because of issuance of appointment orders was delayed, petitioners cannot be denied benefit of pension.
Same.
Now the present review petition. Present review petition filed by the government against the judgment and order passed by the Honorable Justice Acting Sridhar Rao in WPC on the grounds entirely that writ petitioners herein were appointed on 21/12/2005 after new defined pension rules of 2005 came into force on 1/2/2005, and therefore they cannot be governed by the existing pension Assam Services Pension Rules 1969. Rather, they would be governed by the new defined contributory pension scheme introduced by so-and-so. Letter dated 9/3/2005 of Deputy Commissioner to Commissioner was not brought to the notice of the court while the court passed the order. This is my submission, my lord. This letter which I am showing. And then letter dated 9/3/2005 clearly says that petition could not be appointed due to non-availability of vacancies, expiry of validity of the list.
But you cannot say that this letter was not with you during the hearing of the writ petition.
Well, that is
You have to show that that was not
my lord, yes,
in your knowledge.
that was not brought to the notice of the honorable court by other parties. They are also equally responsive, my lord. They have asked for an order without producing the relevant.
They will not place this. This is not in their favor. You will have to place, and this you cannot say that you did not have the
That is
knowledge.
correct, my lord. That is correct.
So where is the ground for review?
My lord, lordship will kindly have
Error apparent. Error apparent is not there.
My lord, I'll show my lord error apparent. Lordship will kindly see in the review petition the order passed by Justice Sridhar Rao, page 19
Page 19 of?
of the review petition, my lord.
So this 5072 was disposed of by holding that they are entitled for the old pension scheme,
Yes,
5072 of 2007.
my lord.
Then how come a new writ petition?
They have filed a review petition possibly during the pendency of that, or maybe subsequently they want the pension, my lord.
This new is 2016 after so many years.
Yes, they filed a fresh.
So why did they file this fresh writ?
I think
Where is the
They have paid for pension on, in terms of that, my lord. They have filed the writ petition afresh because in view of the.
they gave their representation
And it was not.
and then
pension
some
was-
opinion was again sought for.
And pension was not paid as in terms of their judgment
Acha.
under review, my lord. If your lordship kindly goes to that order, my lord, lordship will find
Page number what you said?
page 19.
19. Yes.
Applications were invited for posts of Mandal in Darang district. Petitioners applied for the post. A total of 38 persons were selected. Of them, 23 were given posting and rest of them were not, despite there being vacancies. This
Vacancy.
is not correct. Deputy Commissioner appears to have written a letter to the Commissioner to appoint fresh rest of the persons in the select list. There were no orders from the Commissioner. Therefore, the persons who are left out from being given appointment order filed writ petition W so and so before this court. This court by order it is so and so directed to appoint the petitioner. Appointments of the petitioner were made on so and so. This should be.
No, this is different. This is not in respect of the present petitioners.
Well, this is in respect of petition only.
Appointments of the petitioners were made on 1/2/2020 to 2005. This is a mistake,
But this is typographical error.
which is corrected later.
It was
Acha.
corrected later, my lord. State brought into effect new pension rules with effect from 1/2/2005.
This is same order which was placed by Mr. Didas, 21/7/2014.
Same order, my lord.
But there I didn't see the vacancy what? I skipped or what?
This order is there only in the review petition.
How come there are two different letters, two different orders? Let me see this order of Mr. Justice Sridhar Rao in the writ petition of the later writ petition.
No, later writ petition is not by Justice Sridhar Rao, my lord.
No, 21/7, yes.
21/7 is the order of which I am seeking review.
Despite there being vacancies. So
Ah.
there were vacancies.
No, there were no vacancies. That is what I am saying, my lord. This order is not correct because vacancies were not there.
So you mean to say that letter was not placed, but then the letter was in your hand. You should have placed it.
That is correct. But then fact remains, my lord, that these if the vacancies were not available, and if that issue is not considered, question will be whether they are entitled to this order, my lord.
Wait, let me see the earlier letters.
Ninth,
Wait.
9th of March,
9th of March is the letter you have placed.
my lord.
Office order is this what? Wait 1 second. Where is the letter where ban of appointment was shown, Mr. Das? The State Council, in the order dated 17/12/2004 by Justice Anima Hazarika,
Yes, my lord.
somewhere there is a,
Page
the Mr. Mahanta, page 23 of their writ petition.
Yes.
Mr. Mahanta had submitted that at present there is a ban of appointment imposed by the ban
Yes.
as submitted by the government. It cannot be appointment in terms of the letter dated 7/9/2004 to be made. So the reason for not appointing them is because of the ban.
And my lord, I may point out, my lord, in that 17/12/2004 order,
Hmm.
second paragraph, on consent of the learned counsel for the parties.
Wait.
My lord,
Oh,
second
yes,
paragraph,
on consent
my
of,
lord, both
Hmm.
parties were represented. Nothing prevented the state to take this point, my lord,
Hmm.
at that relevant point of time. And
Con-
this order was
consent-
passed.
consent to
consent to
dispose of the
dispose
matter.
yes.
Yes, my
But then still, because things had come to an agreement,
my lord.
Consent for the disposal.
Yes, definitely, my lord.
hmm,
So far as the ban is concerned, my lord, that order is, this order
Hmm.
is reflected.
Anyway, let me
And
complete my.
nothing
Ah, yes,
prevents
yes.
the state take this point, my lord.
If your lordship goes
2004, my
to
lord.
that order, page 19,
hmm,
lordship, I'll read further, my lord. So far as that date is concerned, that date has been subsequently corrected by a review petition. And
that
order-
we have seen.
That order is annexed there.
That.
Page 20,
Then I go
my
to the
lord.
next page, page 20, my lord.
Hmm.
এই বইলো, check করে দিচ্ছি। It is the case of the petitioner that 23 persons who were appointed,
Page
And-
20.
20. I'm
Sorry.
continuing, my lord.
Uh-huh.
It is the case of the petitioner that 23 persons who were appointed
Right.
and whose
Hmm.
names also figured in the select list were given the benefit of pension, but petitioners were denied the benefit of pension because of delayed appointments. It is therefore said that the action of the state in denying the pension is discriminatory.
Hmm.
The counsel for the petitioner relied upon the decision of the Supreme Court in State of Bihar versus Mithilesh Kumar,
Hmm.
2010 13 SSC
Hmm.
467, wherein it is held that the norms or rules as existing on the date on when the process of selection begins will control such selection.
Hmm.
We are not concerned with selection in this case, my lord.
Hmm.
Selection and any alteration to such norms would not affect the continuing process unless specifically the same were given retrospective effect. Now,
Okay.
this judgment is not at all applicable to the issue involved in the case.
But what do you say? You say that selection process or any process will not include pensionary things.
No, my lord, this judgment is, I have brought the judgment, my lord. This judgment is rendered in the context of appointment. If the appointment is made subsequently, but the process started earlier and the rules were different earlier and subsequently it was amended, in Rangaya's judgment, my lord, reported in 1983, it was said that rules applicable at the time of the vacancy arising will be applied for this filling up those posts. My lord, unfortunately, this judgment was overruled by the Supreme Court in 2020.
That you said. But that recruitment rules will not cover pensionary.
Cover, my lord. That judgment is very clear in the subsequent
But pension is a condition of service.
condition of service, but the judgment, my lord, judgment has to be read in the context in which it is passed. Judgment was rendered in the context of selection, my lord. I brought the judgment, lord, you can see.
Doesn't yes,
Yeah.
but then
It is
same
based-
analogy will be applicable in case of pension also, and pension being
My
condition
lord,
of service.
if that is so, my lord, if today a person is appointed
Hmm.
and a selection process supposing starts,
Hmm.
now no appointment takes place.
Hmm.
After 5 years, if the appointment takes place, the pension rule or any other rule which were subsequently different cannot be said to be not applicable to those persons, my lord.
In fact, yeah, that will be the case unless procedural some changes will be applicable, but the substantive law will remain the same.
And here is a further my lord, fact is there that vacancies were not available. If the
Yes, that Mr. Das has to reply.
Ah.
Well, he is taking another ground that they were not appointed because of lack of vacancies. He had shown one letter of 9th of March 2005.
Yes.
I'll take 2 minutes break.
Yes,
I'll
fine.
come back.
Yes.
So what he had said is this, and he had misplaced one letter, which is not there in the, which you had not annexed. So there it is said they were not appointed because vacancies were not available, even the select list got expired.
But then it's a contrary to their statement which has been made before the learned single judge. They said that
That,
was a
that,
ban.
had- yes, that
There
had,
was a ban.
yes.
Now they cannot take that plea. That plea should have been taken before the learned single judge.
that being available to him that
No,
time.
that been available at that time.
That I have
2014,
said.
my lord, simple. My lord, for your lordship rise, my learned friend said there was no vacancy available at time. Right? That's what he said. If you see a 2014 order, even prior to that, that is not the stand. Their case was that there was a ban. So no appointment. Can he take now that plea that there was no vacancy?
And
This is
document-
a simple
where with
question.
him?
My lord,
Government
answer.
advocate only said. So whether that review will lie.
Yes.
The documents that were available to you that time. And plus, what is the error apparent?
My lord, error is, my lord, if there is no vacancy and if the appointments were not made because of non-availability of vacancy, then the question of giving them.
There is a second point, and that judgment of division bench where no selection had started, advertisement was done, and it is said that the old pension rule will be
My
applicable.
lord, in that judgment, it is clearly mentioned that vacancies were available.
Were shown in the advertisement.
My lord, no, no, vacancies were available. It's
Huh. In the division bench judgment.
yes, ma'am.
No, vacancies were available in this case also.
No, my lord, it was not. That is what I'm
No,
showing.
28 people were appointed against existing vacancies.
For them, the vacancies, I'm not saying, I'm saying about, for them, the vacancies were not available for
No,
which
no.
they could not be appointed.
You are making a distinction with this High Court case.
Yes, ma'am.
Here, even if they say that vacancies were available,
My lord.
appointments were not given, right? Here also is a case where vacancies were available, 28 people were appointed.
26.
My-
page
26.
26.
26 people
Page
were
26,
appointed.
please see.
My lord, my submission basically is that if the appointment process started
Hmm.
and the actual appointment was made at a subsequent date and the delay occurred for a reason which is not attributable to the petitioner and it because of the fault on the part of the respondent, then they should get the benefit. And here is a case, if the appointments were not made immediately and it was made subsequently because of non-availability, this delay cannot be attributed to the respondent. Because if the vacancies are not there, how can they be appointed?
But
That is the- that is why
that
the
was
delay.
not the case of the state.
My lord, my lord, the documents are available, record says this is the position.
It was not
only because
placed.
It was not placed,
Then,
but then.
is there a case for review? Go for appeal.
Well,
Yes. Okay, I'll take 2 minutes
my-
break.
yes,
And
pertaining to the recruitment relates to vacancies which arose for the year 2003. The entire recruitment process took about 2 years' time and pursuant thereto, the petitioners were appointed belatedly in the year 2005, although they were recruited against the vacancies occurring for the year 2003. And then, if your lordship goes to para 18,
Yes. Paragraph 18.
18,
Huh? Yes.
lordship will find in the cases of recruitees, the appointees in the writ petition before the Delhi High Court, which are placed into service by the present proceedings, had all applied for the selection process which was initiated in the year 2003. Process for selection, including written test, interview, and medical examination, etc., were largely concluded in the year 2003. However, in spite of that, appointment letters were issued in the year 2004, and by which time the new pension scheme came into force. Delhi High Court was of the view that since the process of selection had been initiated in 2003 and the appointees had been selected and their selections were concluded in 2003 itself, but because of various reasons, appointment orders were belatedly issued in 2004, such delay cannot be attributed to the petitioners. And therefore, the Delhi High Court came to the conclusion that payers were made in those writ petitions therein, that the recruitees or appointees are governed by the old pension scheme and not by the new pension scheme were allowed, and consequential directions were issued to the respondents to pass the order.
This will be relevant only if I consider that the appointments were not given because of non-availability of vacancies.
Yes, yes.
But that was not your stand before the High Court.
My lord, before
It
the
was
High-
only ban.
we have taken the plea of ban, but that is why we have filed the review. Because if we go for an appeal, the court may say that go and file a review. That is why we file a review. Let's see, vacancies were not available, and therefore the delay in making the appointment was not attributable to the respondent. It is because of non-availability of vacancies that the appointment could not be
See,
made.
even in the subsequent order of Justice Sridhar Rao, it is said despite vacancies being there, then also state government did not say anything.
Well, that is why we are praying for a review, that the submissions made or the failure on the part of the council to point out that order, and also on the part of the petitioner to point out that 9th of March 2019 order, my lord, communication. The finding-
2005.
The finding of the honorable judge was not correct because the facts were not placed. That is why we are before lordship, that in fact vacancies were not there.
But the review is very short, no? Because it is said only those documents which were not in your possession. In those documents, you can show it now. But 2005 letter,
Yes, ma'am, 2005.
before the appointment,
Yes. My lord,
saying that there were no vacancies. Acha, Mr. Das, you had shown some communication showing that,
Will tell your lordship, I'll give three reply, very quick reply. to my
if he has
lordship. Yeah,
finished.
yes, if he
Yes.
has finished.
Mr. Majumdar, anything more?
my lord, that's what I'm saying. Even this judgment, even my judgment on which they are placing the
Yes.
reliance, has considered the fact that vacancies were available. Now we are before your lordship because if vacancies are not available,
Mm.
then whether the delay can be attributed to the respondent so as to say that no, they will be entitled to the pension
In that case, selections were concluded in the year 2003 itself.
fee itself. And here
And-
it was not considered, in fact.
It was not concluded.
Number one. Number two, so most important aspect is when two aspects are there, vacancies were not available.
Hmm.
And the judgment on which reliance was placed by the Honorable Justice Sridhar Rao, my lord,
Hmm.
is out of
Ah.
context.
It is in respect of recruitment rules.
Recruitment, my lord.
Recruitment rules, any judgment that it will not cover pension.
My lord,
Recruitment rules, recruitment.
recruitment.
But yes, prima facie, it shows so.
And the reason is, my lord, today, that is why in Manjushi's judgment also it is said that once the process starts, you cannot change the rules of game in between. Because at that time, a different type of rules were available. The persons who participated in the process, they were of the view that these are the rules, I am competent and that is why I am applying. Now subsequently, if you
They will
change,
be also aware that this pension rule will be applicable.
well, that is what I'm saying, that the
Then any change in the pension rule will again affect their desirability to apply for the
I'll give
post.
to your lordship, but my submission is, my lord,
Huh.
if the vacancies were not available
Hmm.
and the delay in making the appointment was not attributable to the respondent,
Hmm.
and ultimately when the vacancies became available, they were appointed,
Hmm.
they have got the benefit of appointment. So far as pension is concerned, pension rules available on the date of appointment has to be applied to them. This is my submission, madam. And my lord, I'm showing, my lord.
And in the very first order also, this court said that once the ban is over, appoint them.
Yes.
So that was a complete different facts. Here again, you are bringing on a different fact. Anyway, the High Court judgment
My lord.
arose, you are showing that vacancies were there, right? For this relates to vacancies which arose for the year 2003. I'm stating paragraph 5.
My lord.
The entire recruitment process took 2 years and pursuant thereto were appointed belatedly.
Yes.
Although they were recruitees against the vacancies occurring for the year 2003. So vacancies were very clear in the
Very
judgment.
clearly.
This is what you are saying.
Yes, that is my submission, lordship will consider.
Okay. This is yours. All. Yes, Mr. Das.
Let's
You.
give
Huh.
quick replies.
Huh.
First, what my learned friend has projected and what your lordship has put a query to me
Hmm.
is in respect that whatever you say, that there was no vacant post at that relevant time, right? And he has shown one letter, that's our writ petition, which was filed before this court 5072 of 2007.
Achha, that writ petition is
That
disposed of.
petition, yes, right.
Huh.
That petition we have filed, that 5072 of 2007. And the letter which my learned friend has shown 9th of March 2005.
Was annexed
And
to
we
that.
relieve it
Hmm.
annex.
Hmm.
Now, my answer will be that whether you have filed any affidavit in this case, no affidavit has been filed in this
Achha.
case.
Hmm.
Number two, if you see the order passed by this court at page 40, at page 41. See once again, page 41 of this order.
Page 41 of the present writ.
21/7/2014. That
Yes.
order of page 41.
That I have seen, yes.
Lordship has seen, I don't have to read again. 21/7, that was passed in 5072 of 2007.
Achha, that was passed in
Yes.
5070.
What you have done it? Why you have not pointed out? Because number one, why you have not pointed out because that there was no vacancy. There was no, that you did not project.
Why did you annex this?
I annex this. I have brought notice to the court. Otherwise, tomorrow they will say that this is what has happened. But ultimately, the order culminated into this 21/7/2014.
Where it is said vacancies were there.
Yes. No, initial also, if you see at page 26, please see page 26. 31/1/2005. 31 to them, so and so, applicant is a vacant post of Mandal. In 2005, 31/1/2005. That time what, my lord, your lordship knows, the government should have come and said there is no vacant post. The specific stand of the government if there is a ban. So no appointment could be made.
Mm.
If you are aggrieved by that order.
This order was before this letter.
Yeah, no, my lord, if you are aggrieved,
Mm.
if you are aggrieved by that order, you know it, that there is no vacant post, you could have preferred an appeal against this order.
Mm.
One. Number two, the order of this bench 2014, no appeal has been preferred. We came, and what is the subject? There are two writ petitions. One is my appointment. Correct, my lord? One appointment passed by this court in 2005.
Mm.
You should be appointed. Whenever the ban is lifted, you should be appointed.
Mm.
One. Secondly, when I was appointed in 21/12/2005, then they said you are governed by the new pension rule. I came to this court in 2014.
Mm.
The 2014 was the judgment. And what was the case? The case was about whether I am entitled under the old pension rule
Mm.
or new pension rule. Government was heard. They did not file any affidavit to the effect. And ultimate court said no. Relying on a judgment of Mitles, when the process has started, long back in 2099, that selection process which was started, so you will be governed by that only.
Mm.
So I should get the benefit of that's what the learned singles in 2014. Now they have come up and they file a review. Your lordship, no review is very limited ground. Now, if you see order 47 rule 1,
There's an
see order
SPPC.
47
CPC.
rule 1, my lord.
Mm.
Very clear. See order 47 rule 1.
CPC, no,
CPC,
CPC.
CPC.
Acha, that or review of which order?
Review of the order passed by at page 41 or the order of page 41.
No, this is in respect of another writ 5072.
That's not the case. 50 page 41.
That was
There's a
filed in
5072. 5072, my lord.
The review is filed in 5072.
Yes.
5072 is disposed of. Acha,
Yes, yes, disposed of. 507. Review is filed in 5072 of
and
2000
5066 is for what?
50?
66? The one that you have just you started with?
Yes.
That they have
New.
filed before we filed
This is
the
new
review.
writ.
New writ petition, yes, new writ petition.
Pensionary benefits.
Whether it should be an yes.
And 5072 was for your appointment.
507 whether I am entitled to get the benefit under the old or new pension. And this petition, this petition before this honorable court is that all this they have forwarded the letter in person to order passed by the court. DC sends to commissioner, they want a view, but they have not passed any order
Mm.
whether I am entitled in person to the order passed by this court.
Mm.
Despite my repetition which has been passed.
No. 5066 is for your pensionary benefit.
Correct.
5072 was for your
Whether I am entitled for getting new pension or the old pension.
same.
Yeah, no, it's a different mind.
No. 5072, let me see your prayer there.
Yes. 5072.
I'll clarify it, man.
Hmm.
Let me clarify. 5072 is the petition where they sought an adjudication as to whether they are entitled to pension under the new pension scheme.
Okay.
So after
Yeah.
Honorable Justice Sridhar Rao passed that order, since they were not paid the pension, new pension,
Ah.
they have come again.
Oh,
Why I have come
After
again?
after that, we filed the review petition.
Why we have come again?
Hmm.
Why I have come again? Because of 2015, where the communication was sent by DC to the
Hmm.
commissioner.
Hmm.
That this is what the order has been passed.
Hmm.
It was sitting and
Hmm.
it was sent. Nothing has been done from this.
Ah, yes.
That's what.
Hmm.
Yes. This is what we have. And my lord will kindly see now the review
Hmm.
under order 41. This review is not maintainable. My lord.
Uh-huh.
Please see order
Yes.
47 rule 1.
Hmm.
Lordship got it?
41.
Rule 1.
Hmm.
Any person,
One second, I have not got. Yes, 41, yes.
47 rule 1.
Hmm.
And any person considering himself aggrieved,
Hmm.
a decree and order from which an appeal is allowed, but from which no appeal preferred,
Hmm.
by decree order from which no appeal is allowed, or by decision or reference.
Hmm.
And who,
Hmm.
from the discovery of new and important
Matter.
matter
Hmm.
or evidence which after excess of due diligence was not within his knowledge,
Hmm.
or could not be produced by him at the time when decree was passed or order made, or on account of some mistake or error apparent in the face of record, or for any other sufficient reason, desire to obtain a review of the decree passed or
order made against him may apply for review of the judgment to the cause which was made, which was passed, the decree or made the order.
Mm.
Now here is a case where you knew about that there was no vacant post on 9/1/2005.
And the letter was there on record.
There on record. Secondly, 2014 when the judgment was passed, even also you knew it, that letter.
Mm.
So now you cannot bring before the court filing and review, relying on the 9/1/2005, which you cannot seek any remedy before this court for reviewing this order. Because this is, my lord, this goes against you.
Mm.
And to this effect, there is one judgment of the Supreme Court 2022. There are other judgments, old judgments, but I am giving one new judgment 2022, 17 SCC page 255 on the point of reviews.
On the point of
Review.
review. acha.
Yes.
Okay.
2022, 17 SCC page 255.
Hmm.
Please note down para 26 to 33. I will not go through it. The principle that has been relying on all the judgment of the Supreme Court.
Okay.
So this is my answer to this court, my lord.
Yes.
And
Right.
only that division bench judgment,
Huh.
paragraph 28 is the conclusion, my lord.
Division bench judgment.
My lord.
Yes.
And there, my lord, ultimately, the Supreme Court has held that because of the delay was attributable to the
State.
state.
Okay.
And
Right.
my lord, my lord, just the, in the judgment under review, my lord, reliance was placed on a judgment of 2010, 3 SCC, my lord. That is,
Bihar.
Mithilesh. my lord.
Mithilesh, Bihar.
In that judgment, my lord, reliance was placed in that Rangaya judgment of 1983, 3 SCC.
Acha.
And I'm just showing the subsequent judgment of 2023.
Where it is said overruled.
Oh, yes. I'm just pointing out so that, my lord, I don't fail in my duty. 23, 3 SCC, page 773.
Okay. Where it is overruled.
Overruled
Rangaya
is-
case is overruled.
Yes, and my lord, it is clearly held that that judgment of Rangaya did not lay down any law, but that has been consistently being followed. This is what the observation of the Honorable Supreme Court.
Yes. That recruitment rules, basically on the
That
rules.
is, yes, ma'am.
Rules which were applicable.
At the time the vacancy rises, it has to be applied for filling up those posts.
But these are matter which is an appeal would have been filed against the judgment. The General Single Judge are wrong. This is what, so appeal could have been filed. That is why, my lord, 2022 17 SCC, if you see para 33, see para 33, my lord, para
Yes.
33 of the judgment. See para 1 judgment, where from 26 to 33, I'll take para 33 only. See para 33.
As can be seen.
As can be seen from the above exposition of law, it has been consistently held by this court in several judicial pronouncements. Court jurisdiction of review is not the same as that of an appeal. A judgment can be open to review if there is a mistake or error apparent on the face of record. But an error that has to be detected by a process of reasoning cannot be described as an error apparent on the face of record for the court to exercise its power to review under Order 47 Rule 1 CPC. In the guise of exercising power of review, court can correct a mistake, but not substitute a view taken earlier merely because there is a possibility of taking two views in a matter. So a judgment may also be open to review when any new or important matter or evidence emerges after passing of the judgment, subject to conditions such evidence was not within the knowledge of party seeking review or could not be produced by it when the order was made, despite undertaking an exercise of due diligence. There is a clear distinction between erroneous decision or against an error apparent on face of record. An erroneous decision can be corrected by a superior court, or an error apparent on face of record can only be corrected exercise review jurisdiction. Yet another circle referred in Order 47 Rule 1 for reviewing the judgment has been described as for any other sufficient reason. Said phrase has been explained to me a reason sufficient on ground, at least analogous to those specified in the rules. So and so, so and so. So this is.
So this other sufficient reason
Yes.
will be read in consonance with error apparent or the document not in their
Yes, right.
knowledge.
Absolutely correct.
It's just them generous
Yes.
kind of.
I deeply oblige. Sir. That's my.
Okay. Yeah. Yes, Mr. Das, you can proceed for other case. My dictation will take some time.
Yes, I'm deeply.
One thing.
Mr.
Yes,
Majumdar
ma'am.
also.
I'm just pointing out, my lord.
Hmm.
Lordship, excuse me. The judgment, reliance on this judgment of 2010, that Mithilesh Kumar, itself is an error apparent to the face of the record. A judgment which is not applicable to the facts of the case has been applied. Anyway, that Lordship will take into consideration. Otherwise, my lord, the very object of filing this review is that this should not open a floodgate to many such appointments where the state is otherwise not responsible for the delay. Because once, if your lordship passes generally.
Every case will depend on its
That is
own
what
facts.
Lordship will kindly see that it is not made applicable to those who are not before lordship.
Mm,
Because
this will
once
be
it is made.
peculiar facts of this
Yes,
case.
my lord. Otherwise, it will open a floodgate, and there are many such appointments where because of some valid reasons.
Now
appointments
what
are
to
not
do?
made.
State commits mistake, what to do? But then this will be peculiar to these facts.
Ma'am,
Let's
that-
see what happens.
I'm deeply obliged.
Oh, it's okay.
But
Heard Mr. D does.
I can
learned-
leave my.
Yes, yes, that's what I said. Mr. Majumdar, you
Ma'am.
can also. Your juniors are there, I will take their assistance. Yes, heard Mr. D does, learned senior counsel assisted by Mr. It will likhisilu. Oh, in another matter. As does learned counsel for the petitioner. For it to be reviewed likha. Heard Mr. R. Majumdar,
the citation, have I given that citation of the judgment?
Rangayas.
Yes, no, well, it's the recent one by which it was, Rangaya was overruled,
Yes, 2023, 3 SSA,
page 773.
773.
Ma'am.
Yes, they have given. Reviewed likha.
Deeply obliged.
Hmm. Reviewed likha. Heard Mr. Majumdar, learned counsel for the review petitioner, and Mr. D Das is senior hetudia assisted by so and so. Review to court. For respondent number, for the respondents. No. For some respondent, it is a sort of. There is one official respondent, I think, right? Or, oh no, how can there be? Wait, performer? Yes, 7 is a performer respondent. 1 to 6 will be. 1 to 6. No, not 1 to 6. You are appearing for 1 to 5, right? There were 5 candidates only. Yes, 1 to 5. Anybody appearing for the deputy commissioner, government advocate? Oh, yes. How can there be clash of interest? But it's okay, 1 to 5. This application was filed under Orders 47, Rule 1, CPC 1908, seeking review of the order dated 21/7/2014, passed in writ petition number 5072 of 2007. Before going into the facts narrated in the review petition, as well as the law, this court would like to narrate the facts involved in the said case. It is the case of the petitioners in writ petition number 5066 of 2016, that an advertisement was issued on 18/9/1998 calling for applications from the intending candidates who had passed the Assam Survey Training Examination. Fan de dijiye na. Oh, Hamenda, fan kon di diyo na. Training for filling up post of mandals, for filling up the post of mandals lying vacant in the amalgamated establishment of the Office of Deputy Commissioner, Dorong. In pursuance to the said advertisement, the selection process started and the select list was prepared. Select list of 38 candidates was prepared on 19/6/1999, wherein the petitioners appeared at serial number 29, 31 to 35. It is stated by the learned counsels that the candidate appearing at serial number 32 as well as 35 had expired. However, pursuant to the said select list, 28 number of candidates, 28 candidates were appointed, right? 28. Otherwise, there are two more, 30 and 31. 28 candidates, right?
Yes, ma'am.
It's okay, you write 28. 28 candidates were appointed and the petitioners were not appointed in the said post. Full stop. Aggrieved thereby, the petitioners filed a writ petition being WPC number 9299 of 2004, and the said case was disposed of in the motion stage itself on the consent of the learned counsels for all the parties.
Ma'am, it is 23 out of 38.
28 out of 30.
23 out of 38.
23.
Yes, ma'am.
What about the others? Something happened. It's 23, dear. Instead of 28, huh? Full stop. By the order dated 17/12/2004, this court gave a direction to the Commissioner and Secretary to the Government of Assam, Revenue Department, oh, nalage. Line to nalage. During the proceeding, a motion stays itself, hasana? Yeah, let that remain. On the consent of the learned counsel for all the parties. Okay, full stop. During the proceeding, the learned counsel for the state submitted that the petitioners could not be appointed due to a ban imposed for appointments, and that they can be appointed once the ban is over. And on the said submission, this court gave a direction, gave a direction to the Commissioner and Secretary to the Government of Assam Revenue Department, to appoint the petitioners in accordance with law. and the said writ petition was disposed of. Para. Against the said order, dated 17/12/2004, a review application was filed by the petitioner কি করলো? A review application was filed by the petitioner, praying therein that it was not the commissioner and secretary. It was not praying therein that the appointing authority is not the commissioner and secretary to the government of Assam Revenue Department, but the direction is required to be made to the deputy commissioner, Dorong Mongoldoi, to appoint the petitioners in the vacant post of Mandal.
In view of the selection and successful completion of training.
The petitioners stated, petitioners filed the review application since they came to know about the said fact after the aforesaid writ petition was disposed of. In view of the said submissions, this court had reviewed the order and directed the Deputy Commissioner, Dorong District, to appoint the petitioners in the vacant post of Mandal after getting approval from the government and also after the ban of appointment was lifted. Ban on appointment or ban of appointment was lifted.
Well, immediately there, immediately what is?
Uh-huh.
Immediately after ban was lifted.
Immediately after ban was appointed. The said review application was disposed of on 31/1/2005. Para. Pursuant to the said order, an office order was issued by Deputy Commissioner Dorong Mongoldoi on 21st of December 2005, by which the petitioners were appointed full stop. It was stated in the said, it was stipulated in the said order that petitioner number 1 was appointed again, petitioner number 1, petitioner number, acha, who is, names are not there. Original copy is there. Yes, original copy is there. Petitioner number 1, then on being, the photo state is not good. I mean, the original copy, photo state of the original copy is not. See there, the petitioners were appointed against the existing vacancy, right?
And my lord, one important line which is mentioned in the at page 28, my lord. In pursuance of the approval of the governor of Assam. My lord, kindly see the third para at page 28.
Yes.
Now in compliance of the Honorable Gauhati. High
Yes,
Court's
I've got
order
it.
dated
Now, in
so-so,
the order also, it is said that
approval of the
after
governor,
approval.
madam.
Now, in the order also, it is said after approval.
Yes, so
From
therefore
the
that
government.
approval is there. In
Approval
page
is there.
28, that approval is also there
Mhm.
by the governor.
Yes. It is stipulated? No, of course no. That petitioner number 1, 3, 4, 5, and 6. 3, 4, 5, and 6. Petition number 1, 3, 4, 5, and 6 were appointed against the existing vacancy. And petitioner number 2 was appointed, petitioner number 2 was appointed in place of an employee who had retired. Full stop. The said order also reflects that appointments were made in pursuance to the approval of the Governor of Assam, dated 9/12/2005. With the further stipulation that petitioners were appointed as they appeared in the select list prepared in the year 1999. Full stop. Para. In the meantime, that is on 25th of January 2005, the government had introduced
New pension rules.
no, the new pension rule was introduced on 25th January only,
Yes, madam.
or it is just a letter.
This is a, I think this is a letter dated
1st of February
Yes. 1st of February came.
into effect. On 25th of on 25th of January 2005, the government, the Commissioner and Secretary to the Government of Assam, Finance Department, by a communication to the Additional Chief Secretary to the Government of Assam and other authorities, had informed that the new pension scheme has been formulated by introducing a similar, formulated by introducing a contributory pension scheme applicable to the future state government employees who will be in the service of the state government on or after 1st February 2005. And that henceforth, in all the advertisement, see here it is said in the second paragraph, it has therefore been decided that henceforth the following shall be incorporated in all advertisement for filling up the post for vacant post, as well as in the appointment letters.
Yes.
Mr. Majumdar said that pension is a different thing and recruitment rules. That negates, because that is a service condition
Yes,
in the appointment.
Yes, madam.
So there's this High Court judgment, no, not High Court, I think this Bihar judgment
Yes, madam.
is applicable.
Yes, madam.
Of course, Bihar judgment is decided on Rangaya and a Rangaya is overruled. That is a separate issue. But recruitment rules covers pension also.
Yes, ma'am.
Okay, henceforth, the new pension rule will be mentioned both in the advertisement as well as in the appointment letters. And also that the government servants who are appointed on or after 1st of February 2005 have to give an undertaking that they will be governed by the new pension scheme. Pursuant thereto, the petitioner had filed a writ petition being WPC number 5072 of 2007, praying for a direction that although they were appointed after the new pension scheme came into force, but they having selected in view of the select list of 1999, they should be given the benefit of the old pension scheme, that is Assam Service Pension Rule 1969. Full stop. During the proceeding of the said writ petition, this court, by order dated 21/7/2014, passed an order that 23 candidates were appointed from the select list of 1999, and the rest of them, that is the petitioners, could not be appointed. No, were not appointed, could not be nominated. Were not appointed, despite their, it was said order that the deputy commissioner had written a letter to the commissioner to appoint the petitioners, to appoint the rest of the persons of the select list. For which, select list, but since the same was not done, a writ petition as stated above was filed, and the appointments were finally made on 25/12/2005. 21 or 25? 25, right?
21.
21. 21/5.
21/12.
21/12/2005. This court, while passing the said order, had relied on a decision of the Supreme Court in state of Bihar versus Mithilesh Kumar, reported in 2010 13 SCC, 2010 13 SCC 467, wherein it was held that norms or rules which existed on the date when the selection process started would apply to the entire selection process unless an amended rule or norms provides for its retrospective operation. This court, therefore, held that since new pension rule, had come into effect from 1st of February 2005, and the select list was published on 19/6/1999, the petitioners would be covered by the old pension scheme. More so, due to the fact that their appointments were delayed more so, their appointments were simply delayed but were given from the same select list. Para. Thereafter, the petitioners made representations before the Deputy Commissioner Dorong Mongoldoy, various representations were Mongoldoy, bringing into the notice of the said authority about the said judgment and order. About the said judgment. Thereafter, on 22nd of May 2015, the Deputy Commissioner Dorong Mongoldoy, by a communication to the Commissioner and Secretary to the Government of Assam, had written that since the appointment of the petitioners were from the select list of 1999, since the appointment of the petitioner was delayed but was from the same select list of 1999, and also due to the fact that this court had given relief to the petitioners, this said Deputy Commissioner requested the Commissioner and Secretary to the Government of Assam to communicate instructions so that the representations of the petitioner can be disposed of at the earliest. Thereafter, a number of communications went on between the authorities concerned. And finally, a comprehensive note was put up by the Additional Deputy Commissioner Dorong Mongoldoi. Stating the same facts and further asks for the views from the finance department or what? PNPG? Acha. Asks for views of PNPG department for awarding pension to the petitioners under the old pension scheme. Under the old pension rule of scheme, whatever.
Pension and public grievance, PNPG.
Acha, pension and public grievance, huh? PNPG is a likhe diba.
Sure.
Then these are all communications, right?
Yes.
Thereafter, what happened?
On represent.
Thereafter, a committee was constituted to look into the grievance. And in the meantime, the petitioners were busy with their work assigned to them. Acha, it is a order to the dislo 2712. Hetu tumi eta likhi diba. By that order, it was disposed of. Roba, kuntu order asle it is a the impugn order, the review order is a 21/7/2014 J.
Page 41. of-
Page 41. Huh?
of 50.
This is the order which is sought to be
Yes,
reviewed.
Yes, yes, ma'am.
And why it has come out after so long? The review application was filed on 2017.
2017.
2017.
Yes, ma'am.
Tarpisot did ya? By the said order, the writ petition was disposed of. Writ petition being writ petition number 5072.
Of 2007.
DJ. By the said order, by the said order, writ petition being WPC number 5072 was disposed of. 5072 of 2007. 7 was disposed of. Para. It is the order dated 21/7. It is the order dated 21/7/2014, which is subjected to review by filing the review application being review petition number 156 of 2017 before this court. The main grounds of review, I'll just dictate for another 5 minutes, then the main grounds for review, a review application filed by the state of Assam, Lydia. Filed by the state of Assam. The main grounds of review as submitted by the learned Additional Advocate General, Mr. Majumdar, is that the appointment of the petitioners was not given due to non-availability of vacancies. And he relied upon a letter dated 9th of March 2005, which was written by the Deputy Commissioner Dorong to the Commissioner and Secretary to the Government of Assam, Revenue Department, Dispur, in which it was stated that although 38 candidates were selected for appointment to the post of mandals as per the select list of 1999, only 23 candidates were appointed, and the other selected candidates could not be appointed by that time due to non-availability of adequate number of vacancies. Adequate, it's not saying that number of vacancies, yes, adequate. So some vacancies were there. Adequate number of vacancies, and also due to expiry of the select list, which however was select list. It was further stated that presently, that is on 9th of March 2005, there are 61 numbers of post of mandal lying vacant in the amalgamated establishment of the DC Dorong, Mongoldoi. He did not read the rest. Read the rest, Mr. Das.
Yes, my lord.
Now it has been so, by this March 2005,
Yes.
post became vacant, right? And then the matter of appointment of so-and-so were brought to the notice.
Yes.
And they have also referred to the review order. And in pursuance to that, they have appointed.
Yes.
So the same process was going on. Okay, ki kolo? Amalgamated, heri, ki koi, kot kolo? Amalgamated establishment of the DC, Dorong Mongoldoi. And further prayer was made that due to work pressure, government approval was sought for appointment of the petitioners in the vacant post of mandal in compliance with the review order dated 31/1/2005 passed by this court. The Learned Council for the State of Assam as such submits that since the appointment could not be made due to non-availability of vacancies, and the appointments were made after the new pension rule has come into force, the petitioners would be covered by the new rules and the same being an error apparent on the face of the record, this review needs to be allowed. He further stated that by virtue of the new pension scheme, the undertaking was called for, was sought for, right? He said that
Yes, ma'am.
undertaking was sought for from the new incumbents, and the same was required to be given.
And that was one of my prayers in 5072.
Huh.
Specifically, that I
Mm.
should not be required to file, give that undertaking.
Mm. And that was not given, I think.
Not given, my lord, because that was my prayer in my 5070.
Mm.
Specific
Okay,
prayer.
rest of the part I will dictate
Yes. And my
in the
lord,
second half na chamber.
and that March 9th letter, my lord was referring,
Hmm.
because this last paragraph was.
That's why I did not write petitioners from incumbents, he said.
Yes, yes, my lord. So far as the last paragraph in 9th March letter is concerned,
Huh.
I'll just trace one line.
Hmm.
I would therefore like to request you to kindly communicate government approval for appointment of
Hmm.
6 High Court petitioners in the vacant.
That's what
post
I
of
said.
Mandal.
Hmm.
So the vacant post of Mandal was also referred here. Now,
Yes.
the state is coming up with
Hmm.
another argument, there was no
Hmm.
vacancy.
Yes, yes.
Even in the March 9th letter also, the vacancy was discernible.
Okay, I'll dictate the rest in the
Fine.
chamber. In the chamber. No, I'll dictate it here. You be there because somewhere I might miss something which
Fine.
Mr. Das had not. Okay. Aru kuba here. He further No, like this I'll give after very. He submitted a list of dates in connection with the instant case, wherein he had stated that letter dated 9/3/2005 of the Deputy Commissioner to the Commissioner was not brought to the notice of the court, while the court passed the order dated 21/7/2014. On these grounds, the review petition, the counsel appearing for the review petitioner submits that there is error apparent on the face of the record, as well as the document was not placed before the court, for which review is amenable to entertainment. Para. Mr. D. Das, learned senior counsel, however, submitted that the letter dated 9/3/2005, 9/3, right? Letter dated 9/3/2005 was annexed in the writ petition being WPC number 5072 of 2007
Annexure four, my lord.
Ah.
There is.
as annexure 4 to the same. And as such, there cannot be any argument that the said document was not placed before the court. And existence of such a document has come to the knowledge of the review petitioner after the judgment dated 21/4/2007. 21/4/7. No,
21/7.
21/7/2014. 21/7/2014. He submitted that since the selection process had started with the date of advertisement, which was on selection process starts with the date of advertisement, right?
Yes, ma'am.
With date of advertisement. That is what date?
No, it is in page 18.
Ah,
Page 18.
Page 18.
1998, page 18,
Yes. Page 18 of?
5066.
Oh. Hmm. On 18/9/1998. And the said process was over on publication of the select list on 19/6/1999. The rules of 1969, that is the pension rules. What was the full name? That is the
Some service pension rules 19.
that is Assam Service Pension Rules 1969 is applicable to the petitioners. No, selection process end no koriba. Selection process ends with appointment, right? And during and the select list, selection process end nalage kati dia to word. And the select list was published, in the year on so and so.
19/6/1999, page 19.
No. On publication of the select list and publication of and on publication of select list, which was dated 19/6/1999, showing the petitioners as selected candidates. The erstwhile rule of A2 1969 will be applicable. He further submitted that the stand of the state while passing the order dated 21/7/2014 was that the petitioners could not be appointed due to ban on appointment, and it was for the further stand of the state that the petitioners would be appointed immediately on lifting of the said ban. And as such, the petitioners were appointed, but not giving them the benefits of the erstwhile pension rules is an illegality committed by the state. And as such, on challenge made to the same, this court passed the necessary order. He relied on the judgment passed by this court, judgment passed by the Honorable Division Bench of this court, in writ petition number 7369, wherein this court had clearly stated on similar facts. Wherein this court had stated that the advertisement was issued in the year 2003 and the selection process had commenced. No, when the advertisement was issued in 2003 and the selection process has commenced, the old pension scheme was in force. And any delay in the appointment of the petitioners, the cause which is not attributable to the petitioners cannot disentitle the petitioners from the benefits of the old pension scheme. And as such, a mandamus was issued to the respondents to treat the petitioners as members of the old pension scheme. He also relied on the judgment of State of Bihar versus Mithilesh Kumar, reported in 2000, I've already Supra, wherein it is held that norms of appointment as applicable on the date when the candidates are selected for appointment. কি করলো? Norms and raw rules. Would be applicable and not the amended rules. He also relied on a judgment passed by the Honorable Supreme Court in S. Madhusudhan Reddy versus Narayan Reddy, reported in 2022, 17 SCC 255, wherein the Honorable Supreme Court had explained the powers of review under Order 47, Rule 1. Para. Mr. Majumdar, learned counsel for the state, however, made a distinction of the judgment rendered by this court in WPC number 7369 of 2021 by submitting that in the said facts, that in the facts of the said decision, the vacancy position was clear and although there is delay in the appointment, the old pension scheme was said to be applicable. Whereas in the instant case, according to the learned counsel, there was no vacancy for appointment of the petitioners. Full stop. For appointment of the petitioners. Para. Before I go into the facts and law, narrated in the review petition, this court would like to quote Order 47, Rule 1 of the CPC. Etu the quote koi diba, huh? A bare perusal, you make a subparagraph. A bare perusal of the aforesaid provision provides that on discovery of any new and important matter of evidence which was not in the knowledge of the party concerned, in spite of exercising its due diligence, and which could not be procured, or which could not be procured by him during the time when the case was disposed of, the same can be placed in a review jurisdiction. Full stop. However, the same is not the case here. The communication dated 9 December 2005. No.
March.
No. When was it?
23.
Or 9th of March 2005
Yes.
was annexed to the writ petition. That is WPC number 5072 of 2007, which was
Annexure 4.
Annexure 4 to Annexure 4, bracket or DD, Annexure 4 was before the court. And the same was placed by the petitioner himself. Oh, no, no, no. And the same was placed governor. Okay, yeah. However, the same was not placed by the councils appearing for the state government during the proceeding of the said writ petition. Rather, it was annexed by the petitioner himself, petitioners themselves. As such, it cannot be said that this document was procured later and the same was not in the knowledge of the state of Assam. And the same cannot be a ground of review as contemplated under Order 47, Rule 1. It is further provided under the said provision that on account of some mistake or error apparent on the face of record, appears in the judgment, the same can be reviewed and the said is also not the case here. Full stop. It is no res integra that the error apparent has to be shown by the party concerned on the very face of the record, not on a deep study of the materials placed, study of the materials. The Learned Counsel for the State of Assam stated that the observation made in the order dated 21/7/2014 that in spite of vacancies, appointments were not made is an error apparent. However, the same cannot be taken into account in view of the fact that it was clearly stated by the State Council that there was a ban on appointment, and as such, the appointments could not be made. And with a further submission, that on lifting of the ban, the appointments would be made. In view of the same, there can be no finding that there has been some error apparent on the face of the record. There can be no finding as to the existence of error apparent on the face of the record. Para. Further, it is noticed in the memorandum dated No, memorandum, no. Further, it is noticed in the communication dated 25th of January 2005 that the government, while promulgating the new pension scheme, had contemplated that the government servants joining the service of the state government on or after 1st of February 2005 should give an undertaking that they will be governed by the new pension scheme. As such, the argument made by the learned counsel for the state that there is a distinction between recruitment rules and the pension provided after retirement cannot stand in the eyes of law. Acha, you had not filed contempt after this order, 21/7?
We filed, but earlier, but because it was time barred,
Huh?
so we had to withdraw.
It was filed,
Barred
but
by
it was
limitation.
withdrawn. Because the other writ petition is also there. That needs to be disposed of
Yes, my lord.
along with this.
Yes, my lord. We
That
took
will-
leave of the court to file this writ petition, my lord, in the contempt proceedings. Which was
That is
allowed.
there. Do you have the order? Hmm. The petitioner having appeared in the select list of 1999 and were appointed in 2005. No, yes. Where was this? Nalage. Further, it nalage, huh? Hey, where was it that it is in the appointment orders, right? Where is the appointment order?
It's in page 19, my lord.
90,
19 of 5066.
19.
Yes, this is select list.
No, the appointment orders.
It's in page 32, my lord. Typed copy at page
Okay,
28.
32. Further, in the appointment order, where appointment order? No, where we got this, they were appointed in view of the High Court's order. We got it somewhere.
My lord, it is in page 32. Now in compliance of the Gauhati High Court order dated 17/12.
No.
32.
In the end of the notice, end of the order, we found it somewhere. I think in the letter of the Commissioner,
Page 49 is the communication method, but my appointment is of. This is the annexure, my lord, page 32. This is dated
Nah,
21st of
this is the
December
annexure.
2005.
no, we got it, I got it somewhere. You also had seen.
But the page 53, this is the note, comprehensive note. I think this is the
Hmm.
initial kind of this.
No, it was on the next page. It was on the next page. Where is it? Was it in 5072? Yes, yes. It was on 9th March letter.
Yes.
Yes, 9th. Further, in the letter dated 9th of March 2005, it was stated that during the said year, 61 numbers of post became vacant in the said amalgamated establishment. And the said issue was brought to the notice of the state government, and thereafter it was felt, what did it, so and so?
Felt necessary for filling up of the vacant post.
Hmm. And the say was brought to the notice of the mayor, and due to requirement of employees to mend the work, a request was made by the deputy commissioner for approval of the appointment of 6 petitioner, approval of the appointment of the petitioners in the vacant post of Mandal in compliance of the order dated 31/1/2005. And in the order dated 31/1/2005, it was clearly held no, it was clearly directed that the deputy commissioner of Dorong, after getting approval from the government, should appoint the petitioners in the post of Mandal, in the vacant post of Mandal. And in pursuance to the said order, a recommendation was made after obtaining approval for appointment of the petitioners to the post of Mandal. and as such, the petitioners were appointed from the same select list published in the year 1999. It is also seen that the deputy commissioner had put up a note on 23/5/2015 in pursuance to the direction given by the Undersecretary to the Government of Assam Revenue Department that petitioners being selected in the year 1999 and appointed on 21/12/2005 in 1999 and were appointed in the year on to 21/12/2005. And nowhere in the said communication, it was stated that the petitioners could not be appointed when 23 candidates were appointed due to absence of vacant post. Full stop. Rather, it was stated in the said communication that appointment of selected candidates started in phased manner, were done in phased manner against available vacant post. Full stop. It was also stated that after giving appointment of 29 candidates, in some documents it is written as 23 candidates. In some documents it is written as 23 candidates. Out of 38 candidates from the select list of 99, 38 candidates from the government had imposed a ban on appointment. And as such, the petitioners could not be appointed. Nowhere in the said communication, it is stated that there were no vacancies available, or that the select list had expired, which of course was clarified by the Learned Counsel for the state that it was extended. In such a view of the matter, the ground taken by the State Council that the fact of non-availability of vacancy not being brought to the knowledge of the court cannot be a ground for review, as the same was neither a case placed, as the same was neither placed nor it was not within the knowledge of the party concerned. Accordingly, this review petition is dismissed, okay? There's some here and there cosmetic change I'll do. Petition is disposed and dismissed. And the writ petition 5066, there your prayer is again to allow you new pension scheme only. And did you get the order of contempt application?
No, my lord.
Acha 50662 is a goodie potom fax can is a dilu hekini kaku diba. I'll make some changes. 50 here to D. Nalage diason. Akoman likhi diason. 5066 5066 or tika. Heard Mr. Didas and so and so. The respondent Monaidla, Didas for the petitioner. If senior counsel assisted by SDA second Didiva and Mr. Majumdar for the state. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for allowing,
Page 15, my lord, prayers.
for allowing them to get the benefits under the Assam Service Pension Rules 1969 and not under the new rules. The case of the petitioner brings it at this, you bring the entire facts, Data facts over. Actually, here you these were the grounds also. Mr. Das has relied on this. Argument will be the same there.
Yes, ma'am.
Aru the dasar argument same hobo. Oh no, Majumdar. The Das's argument will be same, but Mr. Majumdar's argument will be what?
The argument will be same. because-
Can you call him for
Yes,
some
I can
time?
call him.
Because in this writ petition, he will not take that or he will take that vacancy position.
But in light, the review petition is dismissed. Now that order becomes binding until it is set aside by a higher court, my lord. So in light of the order which was passed in 2014, my lord, respectfully, my lord, now this writ petition, my lord, in this writ petition, no other view can be taken, my lord.
So yes. And can I write this that in contempt you had filed, it was withdrawn on the ground?
My lord,
We
I
don't
the
have.
records right.
Okay,
So it was
you
very
hit
quickly.
and Mr. Das will also, Mr. Majumdar will also remain the same. Vacancy position was not there, he will say. Hekhini eke ho, right? And ekhini to disuse hiyote je kamot gosil, yeah, it's there. Then last paragraph to likha. It is seen that in writ petition number 5072 of 2007, this court, by order dated 21/7/2015, page 41, right?
41.
15.
14, ma'am, 14.
No, 41. 41.
Yes,
21/7/2014. 2014, had disposed of the said writ petition had held that merely because the appointment orders were issued on a later date, the petitioners cannot be denied of the benefit of pension. However, after the order was passed, the petitioners had submitted representations before the concerned authority and the Undersecretary to the Government of Assam, Revenue Department, had called for a detailed report from the Deputy Commissioner Dorong Mongoldoi, and the Deputy Commissioner Dorong had given a detailed report on 23/5/2015, wherein he stated that it was at the last paragraph to the dissent, wherein he stated that the petitioners were selected in the year 1999 and were appointed in 2005, and that they could not be appointed due to ban on appointments. However, by the said report, the views of Pension and Public Grievance Department was called for. In the affidavit that you had filed in that writ proceedings, there you had said that no verbal request was received from the petitioners regarding providing them with the benefits. Verbal request, they had made representations. See the affidavit.
Affidavit in third writ petition, 5066.
Yes, 5066. Do you have with Mr. Das, the AO? By the Assistant Commissioner. Respondent number 6. Full stop kori ako dia. Further, in the affidavit in opposition filed by respondent number 6 in the instant writ proceedings, it was stated that the petitioners had not made any verbal request for providing them with the benefits of old pension scheme. No, benefits of pension under the Assam Pension Rules 1969. Benefits of pension under the Assam. It be stated here that petitioners had made representations as stated above to the Deputy Commissioner Dorong Mongoldoi on several dates. Who is respondent number 6? DC.
Assistant Commissioner Dharam.
Deputy Commissioner.
Deputy Commissioner Dorong.
And they have made representation.
Yes, ma'am.
They've made representation before the DC. So in the light of that judgment, I'll direct the DC to pass necessary order.
Fine.
That will do?
Fine.
Because you already have the order of Justice Sridhar Rao.
My lord.
So in view of that order and in view of the representations, direct the DC.
Appropriate government will suffice, my lord, because ultimately DC will come and say that I am not the authority. Then again, there will be another round of litigation.
Okay. In view of the same, it is hereby directed that the concerned authority That is Commissioner and Secretary, as well as the DC,
My lord.
concerned authority.
And the pension respondent number 3, my lord.
Pension and public grievance, I think if requisition comes from Commissioner and Secretary, they have got nothing to do,
My lord.
right? They have to pay pension.
My lord.
Or the concerned authority, it's
My
okay.
lord. Competent government is
Yes. The concerned authority in the government would pass necessary order in the light of the judgment dated 21/7/2014, passed in WPC number 5072 of 2007, as well as the representations filed by the petitioners, would dispose of the matter. Full stop. The said exercise to be done within a period of 3 months from the date of the 3 months would be too long. Within a period of 1 month from the date of the receipt of this order. Petition is disposed of, no order to cost.
Much obliged.
Okay.
Deeply.
So writ petition is also disposed of. Anything else? Tat? No. Okay. Any changes I'll do, but this will remain the same.
Well,
Oh,
the whole
acha,
matters
this one, it is just
2017.
in pet two. এটা paragraph এটা মাজত সোমাই দিবাচোন. Further, the argument of Mr. Majumdar that the case referred in the Bihar case, Supra, eto likhi dibason namto ham.
Mithilesh.
Supra,
Mithilesh.
that is Rangaya, was overruled later by the Honorable Supreme Court. It be stated here that the Honorable Supreme Court observed in the said decision, that is what? What is the name of this decision? 2022-3,
State of Haryana.
State of Haryana, Supra,
State of Himachal.
that,
Himachal. State of Himachal.
or State of Himachal Pradesh, Supra, that there is no rule of universal application, that vacancies must be necessarily filled on the basis of the law which existed on the date when they arose. And that Rangaya case must be understood in the context of rules involved therein. That will do. Every
Madam,
case.
A finding that this decision will be binding upon this judgment only. So that
Oh,
Judge
acha.
Majumdar had.
Okay.
information.
It will last line to Didiba. That the aforesaid findings and conclusions is given in the peculiar facts of the said case. Bas. Of the instant case, peculiar facts of the instant case. Ouch. It. The judgment is good. Every time I refer to him, course of question. Yeah, take it. No, review or read petition. I assign it. Yes, thank you. Three, huh? Three. Yes, Mr. Saikia. Oh, you had to wait for very long.
Right.
Yes, what is this WPC?
In this case, madam, the council was directed to obtain instruction.
Yes, Ms. Bhattacharjee.
Yes, Lordship. Instruction, Lordship. We have instruction, I have flag marked also. First is,
ROP.
yes, lordship.
I just go through the last order. It is also stated petitioners in the meantime.
7/3/2026.
27-4 I'm reading.
27/3.
27-4, it was not listed as.
27-4/26, there is an order by
Yes.
Justice Nair.
Yes, lordship.
Acha, memorandum
Yes, lordship.
by
the-
Karbi
what
Anglong.
Stating lordship, this has not been implemented.
Acha,
What they are actually relying on lordship, this has not been implemented. If lordship may kindly.
acha, they are relying on a memorandum has been entered into between the parent department and the
Yes,
corporation.
yes, but no memorandum. This is the instruction, lordship.
Without the memorandum, they cannot get the ROP.
Yes, lordship, this is the fact.
Let the instruction be, my lord, bring on record by way of.
Okay, that's better. I shall.
Okay,
I
let
shall
him go
bring it
through.
on record. Yes, yes, no issue.
This is Karbi Anglong, right?
Karbi Anglong lordship. And we being the parent organization, Hill Areas Department.
Okay, right. Heard Mr. I.H. Saikia, learned counsel for the petitioner, and Miss M. Bhattacharjee, learned standing counsel. Oh no, learned additional senior government advocate. In the present application, an instruction was sought for from the government advocate as to whether any memorandum has been entered into between the parent department and the corporation and in pursuance of the same, kiba kolo prothomte, in pursuance bile kolo ni. No. And in pursuance of the same, the learned senior government advocate, additional senior government advocate has placed a instruction today which says that there is no memorandum entered into between the corporation and the parent department and the corporation. However, Mr. I.H. Saikia, learned counsel for the petitioner, prays that he may be allowed some time to go through the said instruction. Will you give that instruction or you'll file an
Better I will bring it through an affidavit.
affidavit?
Yes, sir. A small affidavit. Kindly allow me
Okay.
just a week time.
Go through the instruction, in response to which the learned additional senior government advocate had submitted that she would file an affidavit incorporating the said instructions and has prayed for some time. Prayer is allowed. List this matter on 8th of June.
Huh.
8th of,
I
before
shall
that
file
you give
within
him the
I shall file within a week.
8th of June, 2026.
Can I take the instruction?
Oh,
back?
bail hearing. Yes. Oh, yes, the copy of the instruction you have to have. This is the only copy. Okay. I will give it back. Didya. There is no PP again.
Yes.
Oh, yes, yes. I did not see you. You were in the corner. Okay. Why has it come up before me? I rejected.
Yes. Out of 4 accused persons, 2 are in bail, ma'am.
2 are in
Bail.
bail. 2 are inside.
2 are inside.
And these 2 are before me now.
For you. Not
Why the difference between these 4? Why 2 are inside, 2 out?
just to outside because possession was not there.
These two are the
Oh.
In this case.
These 2 possessions, they were recovered.
Yes, police is saying that they are in possession, but the real story is different, madam, which I have narrated.
Hmm.
My lord, just
Yes.
kindly see page 4, para 5, my lord. May I read my, this is the real incident.
No, let me see the FIR first.
FIR.
And where is my rejection order? Show me that.
Rejection.
Did
was-
you annex? I can see one at the last.
Yes.
Joinal Hawk
Rejection page 75.
and Johurul Hawk. This is only in respect of Joinul Hawk.
Journal Hall.
Where is Johurul?
The second one, next one,
Page number
page number 75,
75.
the earlier rejection order.
Okay. Joinul Hawk.
Yes, ma'am.
So from Johurul Hawk, from backpack of Johurul Hawk,
Johurul Hawk.
contraband were recovered. And Joinul was riding the bike.
Police is saying, in fact, Journal was picked up from his, at the veranda from his house, ma'am.
Acha.
This is not written by the police in his FIR.
Acha.
Oh.
Anyways, contrabands were recovered from Johurul.
Johurul,
So item 25 is Johurul.
Johurul.
So now what is the change in the ground?
Changing ground, my lord, the page 4, para 5, ma'am. And this is the real incident.
Paragraph 5.
Paragraph 5.
5 is a long paragraph.
Long paragraph. This is the whole incident, how police picked up, how police manufactured this case, how police might not gathered these persons in a Mandamala bypass, how they were taken to the Suraibari outpost. Then again they come of Patharagandhi outpost.
But those are not additional new grounds.
Madam,
Those were old grounds only.
no, madam. These are not earlier, my lord, not the
Placed.
specific ground, not raised, my lord. These are not specifically, the whole incident was not raised. We are in that we are in that because in earlier grounds, my lord, because the section 47 and 48 notice was served in English in
Hmm.
earlier ground, saying that he was not in vernacular form, which is
Oh, that was the ground for
that was the
ejection.
earlier ground, ma'am.
Wait, I did not read the entire, no?
Yes, ma'am.
Wait.
This was also violation of Mihir Rajeshwar judgments and Bihans Kumar.
Acha.
Mihir Rajeshwar specifically.
Just a second. Okay, so
And
on those grounds on 47, 48 and non-appearance, not placing him before 24 hours was the grounds in the earlier
earlier, ma'am,
rejection order.
rejection.
Now what is the new ground?
Now, new ground, my lord, that while after arrest, my lord, the section 53 of BNSS and earlier section 54 or CRPC clearly says that immediately after arrest, the accused person should be medically examined. However, they were not medically examined by them. They were detained on in the morning of 25/5/2025,
Hmm.
and they were shown arrest in the night of 25/5/2025.
Hmm.
They were produced before the magistrate in the evening, 26/5/2025 in the evening,
Hmm.
as per the jury entries. And they were medically on 27/5/2025 in the evening, medically examined.
Hmm.
So, my lord, section 53 BNSS clearly violated. They are at present stage.
Hmm.
And now my humble submission, my lord. They were detained at 12:20 a.m. in the morning on 25/5/2025,
12:20
12:20,
AM.
12:15 a.m.
12:15 AM on 25/5.
25/5/2025.
Ah.
My lord, which was,
But earlier, it is said he was arrested at 11:30 PM on 25/5.
they were police shown arrest. It was shown arrest. How, my lord, why I am saying, my lord? Because during the hearing of charge, my lord, while framing charge, the learned trial court had mentioned in his charge framing order, saying that both the persons were detained. That means while carrying the substance of contraband at 12:15 PM. It is on 25/5/2025. It is, my lord, in the charge framing order.
Anyway, forget about charge framing order. What does this case diary show?
My lord, case diary shows police shown arrest on 25/5/2025 at 11:30 PM at
Ah.
night.
Hmm.
However, they were detained in the morning, what I have narrated in para 5, my lord. That was not shown by the police.
They were detained,
Detained. So.
arrested at 11:30 PM.
Yeah, my lord. It was shown arrested, my lord. The Supreme Court says the time of detention should be counted. Period of detention. In respect of the producing before the magistrate, 24 hours should be counted from the time of detention to the time of production.
Achha, anyway, that ground you had taken earlier and it was rejected.
My lord.
Mr. MP Goswami said that petitioner was arrested at 11:30. So it was well within 24 hours.
That was not specifically, my lord, raised, my lord. Because your lordship, my lord, I don't know, my lord, your lordship has specifically not gone through that aspect, my lord. I was trying to raise that question earlier, my lord, that issue. But however, that was not specifically looked into. So my humble submission is that this is the real incident which I have narrated, my lord. That the eyewitness is there, that Joinul Haq was picked up from his house, nearby his house, where the crusher machine was situated. It is at the time of at 12 mile. And Johrul Haq, who was actually detained in the 8 AM in the morning. And subsequently, my lord, that Abul Hussain, who was in bail, who was later detained from the Nilam Bazar area, which from a petrol pump.
Acha, you tell me about
And
this.
they were gathered in a Mundamal bypass.
No,
area,
as far as
and case was
Joinul,
manufactured.
as far as Joinul is concerned, you tell me when he was arrested.
He was arrested at the same time, sir. So
But where, that is the ground this time in this application.
yes, and also, my lord, medically examined
Joinul.
Joinul, my
Joinul was arrested when?
arrested, police saying.
Detained.
Yes, ma'am.
Detained when?
Detained 11:20 AM,
11:20 AM on 25/5.
25/5.
25/5/25. Arrested, shown arrested at 11:30 PM.
11:30 PM.
Okay.
And-
And then what is the other ground?
And other ground, my lord, that fact, my lord, my humble submission, during the hearing of charge and charge framing order, the trial court also saying that both the persons were detained at 12:15 AM, my lord.
There is again a discrepancy.
12:15 PM, my lord. Because police is saying that. So while framing, this is.
You say he was detained at
though-
11:20 AM.
No, my lord.
Court says 12:15 PM.
15 PM, my lord. So this is almost only 45 minutes difference here. 11:20.
Whatever it is, there is a difference.
12:15 is a 45 minutes.
And then what?
And another ground, my lord, that after the arrest, my lord, we were not medically examined. Violation of section 53 BNSS.
Not medically examined.
Examined.
Section?
Because
Section?
section 53 BNSS.
BNSS kon dibason. Then? These
And-
are the two grounds.
And these are the three grounds, my lord.
Two grounds?
Two grounds, specifically two grounds. And my lord, that as per the Mihir Rajeshwar judgment, which was, my lord, your lordship, or I have not raised earlier my arguments, my lord. Mihir Rajeshwar judgment specifically saying that should be, that 48 and 47 notice should be in vernacular form.
This has always been gone into.
So these are the two ground, my lord.
Okay, medically this thing I will consider.
Yes.
Okay. On both the Joinul and Johurul.
Jahrul. But
So-
Jahrul was actually detained at 8 AM in the morning.
Johurul,
8 AM, my lord.
8 AM in
the
the,
morning.
on 26,
On 25.
on 25.
Fine.
Okay. So he was taken before the magistrate at
Magistrate on 26th in the evening, the next in the evening,
4:30 PM,
after 4:30 PM,
26/5.
5. And my lord, in both the cases, my lord, the London trial court, while hearing of charge, the time was mentioned at 12:15 PM. my lord.
Both were detained.
Both were detained.
And what about medical of Johurul?
It was also not done
Same.
before production. It was done, my lord, on 27/5/2025 in the evening, 7:30 PM.
27/5.
27/5.
Okay. These are the two grounds.
Yes, ma'am. 7:25 PM on 27/5/2025.
So, okay, Mr. Parasha.
My lord, learned counsel has rightly stated that he has narrated a story. It's his narration, my lord, only, my lord.
Mm.
Because in any, my lord, NDPS case, first step is to, when get the information, a GD entry has been made.
Mm.
My lord, kindly come to page 19, FIR.
Of the records.
No,
No.
main petition.
Page
FIR,
19.
Page 19, FIR.
Mm.
This information, this is to inform you that on 25/5/2025 at about 12:15 PM
Mm.
in the daytime, and
And-
information are received, so and so, Patharkandi.
And he's saying before that. he was-
Information received only at 12:15 PM
Mm.
day. Next, my lord, second paragraph, last line. Fayed Patharkandi PS GD entry number 08/08 dated 25/5/2025 at 12:30.
Mm.
Information got at 12:15,
Mm.
then GD entry at 12:30.
Mm.
Subsequently, they went to the bypass.
Mm.
The team constructed a team and they went to the
Mm.
bypass. Now, my lord, come to page 20. This is a story, my lord, facts. They both came in a motorcycle. They were contraband was seized.
Mm.
Next, my lord, come to page 21.
Mm.
Then second paragraph.
Mm.
Suspected, start from suspected heroin.
Mm.
Fourth line, heroin of 324 grams.
Mm.
The above mentioned recovered items, serial number 1 to 6, were seized by me at 4:30 PM.
Mm.
So seized at 4:30.
Mm.
11:15 they got the GD entry, information, 11:30 GD entry, gone to the spot.
Mm.
Naka,
12:30.
12:30,
Mm.
they went to the spot in the bypass.
Mm.
The contraband was seized and seized by me at 4:30.
Mm.
Next page. This is not where I have come. Yes.
Same, even in teaser list, this is
At
4:30.
page 34, kindly page 34. In the
Mm.
forwarding report,
Mm.
forwarding report, page 34, same thing. Date and page 34, date and time of arrest is 11:30.
34.
Page 34,
34.
34, oh yes.
I did not get, this is a chart or something. What do you want to show from this?
So, no, in the forwarding report itself, it is date and time of arrest is 11:30.
This
From
is
the-
charge sheet. Page 32 is the charge sheet.
34, my lord.
34 is a part of the charge sheet.
In my petition, it is forwarding. report.
You want me
Anyway,
to see the forwarding report?
Yes, forwarding report.
The forwarding report will be before that. Yes, this is page 29. Yes.
Because of the petition. Second page of the forwarding report,
Mm.
date and time of arrest is 11:30 PM,
Huh.
25/5.
Yes.
And they seized at 4:30,
Mm.
seized at 4:30. They, along with the contraband, along with the both accused, apprehended accused person, they went to the police station at 6 PM.
Mm. Where is that? 6 PM?
6 PM in the page
Yes,
34,
yes.
second paragraph.
Huh.
After completion of these formalities, the police party departed from the PO and returned to the police station at 6:05.
Mm.
So chronological, my lord, they got the information 12:30 PM,
12:15 PM.
12:15 PM, 12:30 GD entry, went to the spot, place of occurrence, my lord.
Mm.
They seized at 4:30.
Mm.
After all formalities, 6 PM, they returned to the, my lord, PS.
Police station.
And after detention, that proper arrest is at, formal arrest is at 11:30
So
PM.
detention cannot be before this one, Caesar.
No, before information, he is saying that 11:13
Hmm.
AM.
No, at best, detaining the
He can
people.
narrate any story, my lord.
Ah.
We have to go by the record. And the person 47, 48, my lord, the person wrote already that order already.
That I'll not go
He
into.
is signed in English and he don't know, and all the formalities and court date ended. And now new ground is this, not placing within 24 hours.
Acha, that
Huh?
goes. What about medical
Medical, my lord, yes.
examination?
For death, my lord. In the
Section,
record,
did you say?
I have,
53.
my lord, to verify that, my lord.
Hmm.
The record I have perused, my lord.
Hmm.
In the record, my lord, the production order dated 20, it starts from 28/5/2025. First production is 26/5.
Hmm.
That order is not available.
Hmm.
Whether he has medically examined or not, whether he provide the 47 or not, he understand or not, these all are maybe in that order. That order is not before us, not in the record. I have checked.
Order is in the record, madam. I have seen.
That 26/5.
26 order is also there in the record.
Show him,
No,
Mr. Chaudhary.
No. 28 order I have found. Other 2% were granted because they are not in physical position, they were involved, and co-accused statement and all this, they were involved. But these 2%, one is riding the bicycle, driving the motorcycle, one is in the
Carrying the
riding,
bag.
yes, and in his personal found 324 grams. First order.
Lika heard Mr. H.R. Chaudhary, learned counsel for the petitioner, and Mr. K.K. Parashar, learned APP for the state. By this application, no, the petitioner has filed the application for bail for the second time.
It is on record that they were medically examined in the evening on 27/5/22.
But where is the requirement that they should be immediately examined on arrest?
My lord,
It's
this
not there in
53
section
PNSS,
53.
madam. 53 PNSS.
No, why? I did not
My-
find.
my lord.
Show me. This is the second bail application. ऐना क्या लिखा? This is the second bail application by which the petitioner is seeking for bail in connection with Patharkandi KPS case number.
Well,
Oh no, in connection with special NDPS case number 52 of 2025. I'll just dictate the first portion. 52 of 2025, arising out of Patharkandi PS case number 133 of 2025. Registered under section 21C/25/29 of the NDPS Act 1985, which is pending in the court of Special Judge Sri Bhumi. Yes, where is this?
yes. Just for that, I would like to place a judgment also.
No, first of all, show me from the section.
Examination of arrested person by medical officer. When any person is arrested,
I've read the entire section. Where is that
Yes.
requirement?
that by registered medical practitioner soon after the arrest,
Acha.
soon after the arrest.
And in case of medic.
It is also minor substituted by a judgment also. madam. Judgment is there. Soon after the arrest is made, provided that is medical insurance offense. This is a clear violation, my lord. I would like to place a judgment in this regard.
It's okay. It's written here, no requirement of any judgment. So soon after the arrest. So what do you mean to say? He was never he was examined on 27th.
27/5/25 in the evening.
Now what is the interpretation of soon after?
So this is also.
Show me that.
So I'd like to place the judgment. Mumbai. Maharashtra. Para 34, my lord, page 16.
Hmm.
Para 34, page 16. In the absence of any such statutory provision, the exclusion sought by the learned APP cannot be accepted. On the contrary, section 53 and 54 of the CRPC, 54 means now section 53
Hmm.
clearly show that the medical examination is obligatory after arrest.
Hmm.
The provision of CRPC clearly indicates that the medical examination is to be conducted only after the arrest is made. Therefore, the argument raised by the learned APP regarding the pre-arrest medical exam is required to be rejected. Here, in that case, on the contrary, the fact that the petitioner was taken for medical examination by applying a provision of section 50.
No, here soon after is not interpreted where it is.
Interpreted immediately after arrest, obligatory after arrest. Examination is obligatory after arrest. The provision of CRPC clearly indicates the medical exam is to be conducted only after the arrest is made.
After the arrest.
Done, my lord.
But how soon?
Soon, my lord, immediately after arrest, my lord.
Where is that?
Significantly, police have acted as the next king of the, my lord.
Which paragraph?
Next paragraph, paragraph 35. Minutes.
Don't take me to all paragraphs, take me to the relevant part. Here, this is, the entire judgment is on pre-arrest medical checkup.
This is judgment on, but in that judgment, my lord, the court interpreted that the section 53 of BNSS clearly said that immediately after arrest or soon after the arrest, that should be medical exam.
See, soon before the date, like we interpret in 304B, and soon before may not be immediately before. This is what Supreme Court had said, depends on facts and circumstances. It can be also weeks before. So similar can be the case here, soon after the arrest, maybe after he was produced before the magistrate.
But he was produced the next day in the evening.
26th he was
I just-
produced.
on-
27th you were medically
I was
examined.
arrested on 25, my lord.
I understand, 25.
11:30 PM.
So soon after, whether it will be one day immediately or what, 1 or 2 days, here only a matter of 2 days.
My lord, that 57 CRPC and 54 CRPC, 54 comes first, my lord, then 57.
No, I have seen 53 of BNSS.
This
What
is-
you want to show?
So 53 and 54 CRPC same, my lord. So that production comes part later, my lord. Before that, arrest, medically examined, then production. This is the rule and this is the.
Where is it?
This
Is
is
it
the
provided?
rule, my lord. This is the.
Show
rule.
me that before production. We'll take it up tomorrow. You'll find it. Better judgments.
Mine.
Okay.
From that point, I'll find.
Okay, heard Mr. H.R. Chaudhary, learned counsel for the petitioner, and Mr. K.K. Parashar, learned APP for the state. List this matter again tomorrow. That is, and need not write all those. List this matter again tomorrow. That is on 12th of May.
Well,
Oh, 13th of May. Okay, you come up with some judgments tomorrow. You can take this. Both the cases. Yes, 14 Jamal Ali.
That this is the matter may be password for that day. My senior is legging another.
Who is leading you?
Essay Ahmed.
Oh, S.A. Ahmed. Okay. But this is which year? 2017 matter.
For that day, matter.
You have the records?
Yes, your ladyship.
When can you do it? Day after tomorrow? Day after tomorrow. Mr.
Essay Ahmed.
Your name?
Yeah.
F.A. Ahmed, learned counsel for the petitioner. He prays for a short accommodation. As his senior has some personal difficulty in doing the matter today, prayer is allowed. list this matter on 13th of May. Records have been placed by the learned counsel for
For all the respondents.
for all the respondents. The records may be retained till day after tomorrow.
Yes. Obliged.
Day after tomorrow will be 14th.
May I please your lordship? Lordship, we are the newly engaged counsel, your lordship. So.
For the respondents.
Respondent, your lordship. Need
Yes.
some time to go through the,
Wait, I did over?
after a
16.
week, your lordship.
So Mr. J. Abedin, they are not there. Oh, petition. Okay.
Mr. Y Dole.
Jadav Dole.
Yes,
Dole?
your lord-
Why Doloy? Jadav Doloy?
Yes, your
Yes.
lordship.
Senior Solicitor General.
Lordship.
Okay. Yeah, for respond number?
All the respondents.
All the respondents. Yeah, okay. She wants some accommodation newly engaged. Okay. When can you do it? This is what 2018 matter. We'll have to do it soon.
The matter, actually main part has already ended, the reinstatement part has been done.
Oh, sir.
Actually the issue.
By the
Yes.
office.
Now the matter is pending for the regulation of the pay and allowances, which was not paid to him. And in this regard, they are required to take instruction. And Dole was actually instructed in this regard. And now-
Okay, the matter is in short campus now.
Yes. Lord.
Now that the
Just
reinstatement
that
is
part.
done, only pay
Yes,
part is there.
yes.
Sure.
So when can you do it on next Tuesday?
Next Tuesday, your lordship.
Next
Okay.
Tuesday. 19.
Huh? Okay. Learned
Sure.
counsel for respondent, for the respondents, Miss
M. Burman on behalf of Mrs. A. Gayan.
M. Burman on behalf of Mrs. A. Gayon,
Gayan.
Anuradha Gayon.
Anuradha.
Gayon has prayed that they are newly engaged in this matter. Prayed for some time. Prays that they are submits that they are newly engaged in the matter and prays for some time to go through the same. Prayer is allowed. List this matter on 19th of May.
All right.
Yes, 19.
Lordship,
Yes.
Lordship, due to some personal difficulties, my senior could not appear before this honorable court. So I request before your lordship to fix another date.
See, this is 2019 matter, right? Such old matters has to be disposed of. So,
Only
It
thing
will
is,
be listed on 9th.
Lord, a departmental proceeding of a state bank employee, he has been terminated from service. So the records of the disciplinary proceeding will be necessary.
you don't have it today. Records were called for on the earlier occasion.
Actually, it was
So many orders.
indicated,
Huh?
It was indicated, but I don't think it was.
Okay, you place the records on the next date. Okay,
Can it be on 28th of this month?
20,
28,
28.
28.
Okay, 28. Right. Okay, Miss
I Kumari.
I Kumari, learned counsel for all the respondents. What?
1 to 4.
For respondents number 1 to 4, submits that the conducting counsel has some personal difficulty. So all the respondents, for all the respondents, the conducting counsel has some difficulty in doing the matter today and has prayed for some time. Prayer is allowed. Further, the learned counsel for the petitioner, Mr. M. Das, right?
Yes, Bharali.
S. Bharali. Mr. S. Bharali, learned counsel for the petitioner, submits that the records of the instant case would be necessary for its proper adjudication. Accordingly, the learned counsel appearing for the respondents are directed to place their records on the next date. List this matter on 22/8 of May 2026.
28. Obliged.
Deeply obliged.
May I please?
Hmm.
The matter pertains to regulation of family pension.
Hmm.
Lordship here.
Regulation of service.
Regulation of family pension laws.
Oh,
My lord, it is 2022 matter, lordship. 4
Hmm.
years have already passed, lordship. Till date, lordship, they have not regularized my family pension.
Lordship, here certain views from the Lordship ARTP and PG department, pension department was sought for Lordship. We have received it in 4/5/2026, Lordship. Now we have processed the matter, Lordship, and Lordship, certain documents and a final report has been called from the Director of Health Services Assam. So Lordship, let it come after 3 weeks, Lordship, we will complete the whole matter, Lordship.
you already have the instructions from PNPG.
Yes, we have the views, Lordship, the
Acha.
pension department. So
And
they-
then what you require more from the?
from the government lordship, now the director has been directed to submit a detailed report as per the vacancy of the post that the petitioner was holding from 1998 to the date of his retirement.
Acha, some more instruction is
Yes, yes.
awaited. Okay, heard, Mr. Then, okay, after the instructions are received, but 22 matter not very long.
Yes, Lord.
So on the next date, when do you want?
Lordship, after 3 weeks, lordship, any date.
Okay, heard, Mr.
D. Bhuya, my lord.
D. Bhuya, learned counsel for the petitioner, and Mr.
The
D. Pomunyu, learned standing counsel for health department.
Yes, lordship, 1, 2, and 3.
For health department, Mr. C.K.S. Borua,
For pension department.
for PNPG,
Is what I sent.
pension and public grievance department, and Miss so-and-so for accountant general. Mr. D. Upamanyu, learned standing counsel submits that he has the instructions given by the PNPG department, but he requires some more instructions from the government,
No, lordship, from the director, lordship.
from the director of pension,
Health Services Assam.
from the director of health services Assam.
We have
As
received-
such has prayed for some time to place those instructions. Prayer is allowed. List this matter on 9th of June. On which date an endeavor should be made to dispose of this matter
highly
by looking into the records. 22, Mr. Ken Chaudhary. Now in this hour, Mr. Ken Chaudhary.
Sorry for interference, Malad.
Uh-huh.
This other case, Malad, 24-25, Malad.
The bail
I-
matter.
Yes, I have just checked. He was medically examined on 25 also, 26 also, twice. I have phlegma.
So that can be disposed of then.
Malad, disposal can be tomorrow, Malad, in his presence, but I have checked. Police, Malad, definitely, Malad, in a NDPS case. On the same day, 25, when he was arrested, medically examined. 26 before production, medically examined. Again on 27 also, madam.
Yes, so
3 days.
if you can call him, I can dispose it of today.
Already gone, just I have. Tomorrow, madam.
Okay, tomorrow. Yes, sir.
So he is in legs in another court, lordship, in court 10.
Yes,
Any
yes.
case, lordship, pleadings are complete here, lordship.
Readings
That's why
complete.
it's been for,
Hmm.
fixed for hearing, lordship. Can it become on 2nd of June or 9th of June, your lordship?
Okay.
Subject to confidence of lordship. and,
Okay, as prayed for by the learned counsel is appearing for the parties, list this matter again on, when did you say?
2nd or 9th?
9th of,
9th of.
9th of June, 2026.
Much obliged, Leadership.
Finish me. Okay. Chalo.